My lord, I'm making a very urgent request, my lord. My lord, there is a plot of land, my lord, where, my lord, the petitioner has been in possession from the year 1985. Now, my lord, certain orders have been passed by the Board of Revenue. A civil suit is also pending. I've moved a civil revision petition. I filed a civil revision petition which was to be taken up by Honorable Justice Bhattacharjee. But he has recused from the matter. Now, my lord, at this point, my lord, they've already gone to the property to demolish the property. Now, the property in question is a property, my lord, which has been in my possession for the 1985.
Before that, Mr. Gautam, can this court take up the matter?
My lord, it is a civil revision petition, my lord.
It could be, but perhaps you should have mentioned the matter before the.
I mentioned before the Chief Justice, my lord.
What did she say?
Chief Justice sent me to this honorable court, my lord. Oh. That's why. And my lord, the thing is that, my lord, I have a prima facie case in my favor. I have all the documents to suggest that the possession belongs to me. Now, my lord, if the demolition happens today, my lord, nothing will remain.
Execution is underway?
It's underway, my lord. In fact, even after the matter is filed, it was mentioned before, my lord, the case has been numbered, everything is done. Now, they've gone there to demolish the property. I have so many documents to show that, my lord, the property belongs to me.
That's beside it. Now, what can this court do, or what can
at least stay the execution for as of now, my
when
lord.
the matter is already, I mean...
So, they've just gone there now to seal the property, my lord. At least if some order falls from here today, my lord, at least I'll get some protection.
Even if, let's be practical.
My lord.
Even if an order is passed,
my lord,
by the time the order is processed,
my lord, at least through one of the government councils, my lord, at least they can be informed. Because, my lord, there is a lordship will just hear me for 5 minutes. Lordship will see I have a prima facie case in my favor.
It's not yet. It's not even listed. I mean, not
it is already filed. It was listed before the Board of Honorable Justice Bhattacharjee, my lord.
Not before this court.
My lord, the problem is, my lord, if the demolition, if my lord, its execution is carried out, my lord, nothing will remain in my property. And this is my ancestral property, my lord. I have documents from district council. I have a registered deed of declaration. I, in fact, even have a holding certificate from the same municipal board, which claims the property belongs to them.
That's beside the point. We'll take up the matter.
Well, kindly hear me, my lord.
May it please your lordship. Lordship, I'm praying for some accommodation in item 3. I'm appearing on behalf of Mr. P.R. Paske. I'm praying that this matter be taken up in 2 weeks' time, my lord.
2022 matter.
Yes, my lord. I'm praying for some accommodation.
No objection, your lordship.
What is this matter about?
Cancellation of patta, lordship.
Cancellation of patta?
But the petitioner is in possession, so...
Till date. On pre-made times, there are counsel for the respondent.
3 and 4, my lord.
3 and 4, matters adjourned. Decision after 2 weeks.
Much obliged.
May it please, your lordship. Lordship, I beg to make a mention of item number 4, lordship. Item number 4. On behalf of Ms. R. Datta, lordship, legal aid counsel for this matter. Lordship, she's having some personal difficulties today, your lordship.
2 weeks.
2 weeks, okay.
Highly obliged, lordship.
Please, your lordship. Lordship, I beg to mention item number 7, my lord. I've informed the other side. Item may kindly be taken up after 2 weeks, ma'am.
No objection, your lordship.
7, 2 weeks.
Much obliged.
Much obliged, your lordship.
May it please your lordship. Your lordship, I beg to mention item number 6, your lordship. Lordship, I humbly pray for 2 weeks' time, your lordship.
Yes.
I'm for respondent 1 to 4, lordship. I have no objection from district council, lordship.
Is there also any private respondent?
Yes,
lordship, I believe yes, lordship.
Private respondents there.
Lordship, I don't see them today. It may be taken up after 2 weeks.
2 weeks.
Obliged.
Highly obliged.
Supplementary list, item number 1.
Yes, my lordship, this is a transfer petition, your lordship. What has happened here, your lordship? I've served a copy also to the other side, where they're appearing in the trial court. What has happened here, your lordship, is a suit was filed way back in 2014 in Sora. Thereafter, it was transferred to the district council court in Cousins. Now, what has happened at present is that both the presiding officers who had passed orders in the trial stage, your lordship, they have been promoted as additional judge and judge of District Council Court. Srimati L.W. Pira, the presiding officer at one point of time, had passed an order, Your Lordship, in the capacity of a presiding officer. That order was assailed by way of an appeal before the judge, before Sri E. Mirtent. He was the additional judge at that point of time. Now what has happened, Your Lordship, the appeal was heard by him. Thereafter, he retired. There was no orders passed. Now, Your Lordship, the matter is in a dormant stage. Why? Because neither on promotion, L.W. Pira could not take up the matter, neither S.B. Laitama, who is the judge now. So now the matter is kept in cold storage.
No, the matter is before which court now?
It's before E. Mirten, but he is retired.
Talking before the subordinate district council, I mean the
Now it's in the appeal stage.
appeal stage. Sort of.
So another interesting development also is that, Your Lordship, the post of additional judge also has been advertised. And it seems the examinations also are over. The pending interview and the results. So I'm just praying for 2 weeks' time. If any development comes up, then maybe the new presiding officers, the new additional judge will be. I'm praying 2 weeks' time, so let's see if anything positive comes up, or else I'm praying for a transfer of the matter to July.
Alright, Mr. Idongri, General Counsel for the petitioners, who has submitted that this is an application with a prayer for transfer of the proceedings between the parties pending before the court of the additional judge, District Council Court, Shillong. For the reason that when the matter was initially taken up by the court of the subordinate District Council Court, Shillong, the then presiding officer had taken cognizance of the matter. On appeal, the matter has proceeded before the court of the additional judge, District Council Court. However, on the said judge debating office, another judge has taken up the another judge has occupied the said post, who happened to be the same presiding officer as the subordinate District Council Court. And accordingly, it is but what's the about it? Go to the last line. Who had earlier taken up the case of the parties herein, and therefore could not take up the matter on appeal. In this circumstances, the Learned Counsel for the petitioners has prayed that this matter may be the case between the parties may be transferred to another court of competent jurisdiction, namely the Court of the Judge, District Council Court, July. Next, however, the Learned Counsel has further submitted that it is reliably learned that the post of the additional judge, District Council Court, has since been advertised and the selection process is underway. Perhaps if a new incumbent is appointed, the scope of this application would become redundant. It is therefore appropriate that matter may be adjourned for the time being. Mr. Bharat, you are accepting notice?
Yes.
Has accepted notice on behalf of the. How many respondents are there? How many responded?
One respondent.
On behalf of the respondent. Accordingly, as prayed for, list this matter after 3 weeks. I think by that time, we'll be able to know.
Your Lordship.
Item number 2.
Well, it's item 2. This matter, well, it's
Paper book was to be prepared, Lordship.
paper book.
On the last occasion, Lordship made it clear that paper book would be required. So I have not received the paper book till yet.
I'm sorry, Malaj, I was not on the impression of the paper book.
The status of the paper book.
Well, this is a revision application, Malaj. We need not even get into the paper book because two aspects of the matter, Malaj.
See, Mr. Paul, I think as far as the, that aspect is concerned,
Malaj.
this court has agreed that the matter is to be taken up as an appeal.
As an appeal.
Logic.
So for that matter, then the
Malaj, kindly grant us a week's time, Malaj. I'll ensure the paper book is there.
evidence has to be appreciated,
True.
and for which you have to
True, Malaj.
file paper book.
True. Malaj, this order skip my notice, Malaj. I'll ensure that the paper book is there by next week.
No, colleague was well aware of that.
They were there.
We'll ensure, Malaj, that the paper book is there next week.
Says Mr. K. Paul, our senior counsel, has once again sought for time to file the paperwork on the ground that the same could not be prepared today. Since the paperwork is required for convenience of all concerned, the same may be filed in the next date fix. 2 weeks.
A week's time, Malaj. We'll ensure that there is some urgency, Malaj, because the conviction was of 5 years. I think out of that 4 years is already gone, Malaj. And by next week, we'll ensure the paper book is filed.
After 1 week.
Highly obliged.
Daily list item number 1.
My lords, there are two issues before my lord.
Yes, sorry.
My lord, now this is the legal settled issue that once.
What is this case about, Mr.?
My lord, this is a recruitment, my lord. This is a recruitment process. When the recruitment process has started, my lord, and in the middle they have changed some criterions, my lord. So you cannot change the rule of the game once the game starts, my lord. I will take my lord to page 27 straight away. Page 27. This is the advertisement, my lord.
Yes, sir.
My lord has got.
Just a moment, please.
There's a type copy, I guess. No, that's a. Not all. I will not read all.
Page 27.
Yes, my lord. The page 27. This is the advertisement, my lord. This is the advertisement, and this advertisement was issued on 16 September 2020. And what we are concerned, my lord, is serial number 2.
Yes.
LDA, grade 3, number of vacancies is 46, and pay scale is given, and the third column is given the minimum education qualification, and the last column is given the experience remarks, my lord. And in the experience remarks, my lord, it says you need to have 6 months of diploma course in computer with a typing speed of 30 words per minute, one post reserved for persons with disability, PWD, my lord. So, my lord, the recruitment process, my lord, that has undertaken under this advertisement, my lord, one thing is, my lord, it lacks legal sanction, my lord, and second part, my lord, it lacks transparency, my lord. And why it lacks legal sanction, my lord? Because what it says that the minimum speed, typing speed, that is to be required, that is required is 30 words per minute. Is an essential qualification, my lord. Now, what happened was subsequently, without notification, without after the completion of the test, my lord, it was scaled down. The speed was scaled down to 26 words per minute, my lord, and which is also admitted by the state by the state, my lord. So now, my lord, the scaling down itself is ex facie ultra virus to the advertisement which I've just showed, my lord. Now, my lord, so therefore, which is not permissible in law. So, my lord, in this context, I have already given my my citations, my lord. I would like to refer to the case of K. Manjushri, my lord. K. Manjushri.
What's the citation?
K. Manjushri is it's 2008 3 SCC 512, my lord. K. Manjushri.
Para? Where is that case?
No, I have a copy, my lord. The paragraphs, my lord, which paragraph 5 talks in this case, my lord, I'll just mention the paragraphs, my lord. Paragraph 5 talks about the recruitment in that particular case in K. Manjushri, my lord, is the facts of this case. Paragraph 8, my lord, these are all built up in that case, my lord.
These are the paragraphs you're referring?
Yes, my lord. Just to show that how this K. Manjushri's case came to be built up, my lord. And paragraph 11, I'll just make a mention of these paragraphs, my lord. Paragraph 11, paragraph 12, paragraph 14, my lord. And paragraph 17, my lord, it's after the facts of this case in K. Manjushri. Paragraph 17 is a question of consideration, my lord, in that particular case. Paragraph 17, my lord. Then, my lord, after that, my lord, will come to paragraph 26, my lord. This is where I'm going to read, my lord. Paragraph 26. 27, my lord. 27 was 27. May I read, my lord? Paragraph 27. But what could not have been done was the second change. By introduction of the criterion of minimum marks for the interview, the minimum marks for the interview had never been adopted by the Andhra Pradesh High Court earlier for selection of district and sessions judge, grade 2. In regard to the present selection, an administrative committee merely adopted the previous procedure in vogue. The previous procedure, as stated above, was to apply minimum marks only for written examination and not for the oral examination. We have referred to the proper interpretation of the earlier resolutions dated 24/07/2001 and 21/02/2002 and held that what was adopted on the 30/11/2004 was only minimum marks for written examination and not for an interview. Therefore, introduction of the requirement of minimum marks for interview after the entire selection process was completed would amount to changing the rules of the game after the game was played, which is clearly impermissible. We are fortified in this view by several decisions of this court. It is sufficient to refer three of them. So again, the Supreme Court went on to refer three other cases which says that the rules of the games cannot be changed once the games are started. My lord, there is another case. And also, my lord, there's another case called 2013 4 SEC. 2014. 2004. Tej Prakash Pathak, my lord. I'm just giving my copy, my lord.
2013?
2013 4 SEC 540, my lord. So my lord, I am just forwarding my copy, my lord. Paragraph 7, 8, 9, 10, and 11. Give me. The question, my lord, in this also was whether a rule of the game can be changed or not, my lord. And it has been held once again, my lord, here also has been confirmed that no, you cannot change the rule of the game once the game started. Now, my lord, once you cannot change the rule of the game, then what happens, my lord? By changing this rule, my lord, it has given advantage to one section of candidates, my lord, who were otherwise not qualified in the written in the first test itself, my lord. So therefore, my lord, now once an ineligible candidate gets qualified to the next level, then, my lord, the qualified student, the qualified candidate's right gets affected, my lord. So therefore, this amounts to arbitrary action, because you are giving premium to a section of person who was actually not qualified, my lord. So this also comes to the very root of Article 14 also, my lord. Article 14 and Article 16, my lord. This is one point, my lord, in this. The second point, my lord, the examiners, my lord, have also failed to ensure fair assessment, my lord. We have written an RTI, my lord. I'll just show the RTI reply, my lord. My lord, before that RTI, I'll go to show, my lord, we have filed a representation, my lord, seeking some clarifications from the committee, my lord, and the committee has written to us. Where's that answer? My lord, may kindly come to page 93, my lord. Page 93.
Yes.
This is a reply, my lord, that we got from the office of the Deputy Commissioner East Garo Hills at William Nagar, my lord, to our queries, my lord. And
Yes.
this is addressed to Prinkle Marak. Subject: reply to your petition regarding LDA written exam conducted by the District Selection Committee. Write your letter dated 24 August 2021. So, with reference to the subject mentioned above, the undersigned had received your petition dated 24 August 2021, and the undersigned, after thorough examining the points mentioned herein, has the following para-wise reply against your observation. Number 1, my lord. Correcting of answer script with pencil. Correction of answer scripts for any examination/competition examination can be done with pencil by the examiner, as there is always a tendency to make errors in the tallying of marks, for which pencil is found to be most useful instrument prior to making a final figure or report, rather than using correction fluid, pen or marker, which are objectionable, unacceptable and illegal. Meanwhile, the candidates have marked their responses by pen, and therefore the mark answers cannot be altered. Moreover, once the correction is done, the total score of all candidates are duly recorded and verified by the office concerned. The correction of answer script by the DSC has been done in a fair and impartial manner, as there is a unique answer key for the written examination for the post of LDA assistant, wherein 250 marks of questions and objections type, and only one questions carrying 20 marks in an essay type question, and therefore the possibility of any manipulation of marks does not arise. The correction was done in a clear and bold manner, and the same was verified through multiple levels of checking, including the final verification of the chairman so and so, and after it has chosen 94 candidates of eligible candidates as per the marks secured them in accordance with the provisions made in notification dated so and so. With regard to this observation, it must also be noted there are no particular regulation as to usage of pen or pencil for checking the rules. Now, my lord, the first question that we have raised was correct. The answers were corrected by the examiners in pencil, my lord, and there was no signature. There was no signature of the expert who was correcting the answer script, my lord. So therefore, we have raised the issue of manipulations, subject to easy manipulations, my lord. We have raised that issue. And why did we raise this issue, my lord? Because two results came up, my lord. One result came up in the social media, my lord, and which was disowned by the DSC, and subsequently another result came by notification. What was surprising to us, and why we have doubt that there was no fairness in this assessment, because some of the candidates, my lord, whose name came up in a social media result, my lord, tallies with the notification, my lord. Tallies with the notification, my lord. Now, how one knows which candidate appeared, which candidate is going to be selected? It cannot be a coincidence. It is somebody's work, somebody's hand, the inside work, my lord. Otherwise, as I said, that it's not possible that who's getting selected, who is not getting selected. So how come the social media already flashes a notification which was disowned by them, and some of the candidates' name appeared there, and when they submitted, when they issued the final notification, some of the candidates' name, few changes, some of the candidates' name appeared there. So this is where we say that there was no fairness in conducting the recruitment process. And also, my lord, there is also, the respondents have also, my lord, pointed out that one of the candidate who got selected, because this is a district selection committee, and after they select, my lord, they go to a different department for posting. So one of the candidate who got a posting, my lord, on the verification was found to have submitted some false documents and his service was terminated. So my lord, all this culminates in and give rise to a very strong suspicion, my lord, that this recruitment process itself is marred somewhere. First, you change the rules of the game. Second, your answer scripts are not signed by the characters, and it was done by using a pencil. Third, a notification comes up, a result notification comes up, which you say, no, this is not our official notifications. And after a few days, you are coming up with another notification where some of the names are still appear to be there. And finally, my lord, once you have selected all the candidates and you go for posting on the verification by the department, my lord, found that no, whatever selection that you have done, the candidate it needs to be terminated. Why? Because he secured this job by playing fraud. So all these cumulative situations, my lord, give rise to that. There's a reason why, my lord, we are before my lord. So, my lord, this is a very small case, my lord, where we are trying to persuade, my lord, that this recruitment process, the recruitment process that have taken up, or the September 2020's recruitment process itself, my lord, number one, it's not, it lacks legal sanction and it lacks transparency. And my lord, needless to say, when it comes to a recruitment process, my lord, the full fairness should have been adopted and must adopt, my lord, and which is singularly missing in this recruitment process, my lord. So therefore, my lord, I will humbly pray, my lord, the notifications, my lord, the entire recruitment process that was conducted under this particular selection must be set aside, and also the subsequent result notifications, my lord, should be set aside, my lord. That is the only submissions that I have to make, my lord.
So you were not selected,
my lord. We are.
How many of you are there?
We are, my lord. How many was it? How many of us were there? 20. We are 12 of us, my lord. We are 12 of us, my lord. 12 of us, and 12 of us, my lord. We were already. We have tested the typing test, my lord. But finally, we have not selected, my lord.
So what was the marks obtained by you in the typing speed?
My lord, some of the marks, no, 30 meters above, my lord. We are qualified in typing, my lord. Not 27, my lord.
So, as far as you are concerned, whether the typing speed marks were reduced to 30 or 20 or or whatever will not affect you.
That is not going to affect us, my lord. But what is going to affect is, my lord, what we are saying is, my lord, some of the candidates, my lord, who ultimately got selected, some of the candidates who actually fell in the typing speed, by scaling down, advantage was given to them, and subsequently they got the post.
They were selected.
Yes, they were selected.
You were not selected.
We were not selected. And this also not amount to, my lord.
And the reason is only because of that, the change in the typing speed.
No, it's not only in the change of the typing speed. It's all a cumulative effects, my lord.
But
yes.
Then there has to be. You have to cite specific instances.
Yes.
Of candidate A.
Yes.
Who was selected? How he was selected? He was selected because of such and such reason.
Yes.
Vis-a-vis your selection, you were not selected because of such and such reason. So you have to distinguish, and perhaps even give it in a form of a chart, so that the court at one glance can understand that this was the process that was carried out.
Yes.
The successful candidate were, let's put it this way, were unduly favored because of these reasons, whereas you have not been favored because which perhaps in the final analysis, you are more qualified or more much better than the
That
has to be there.
My lord, I got my lord's point. since this is a very old matter, my lord, I can make an endeavor, my lord, because the selected list is already there with me. With us, it is there, my lord, and if my lord,
Because you see,
yes,
in effect, you are making allegation against those who have been selected.
my lord,
There
yes,
must be some basis.
my lord,
Omnibus, statement will not do.
my lord. I followed, my lord. My lord, if my lord, all I will be requiring is
Another query.
yes.
When this matter was taken up, was there any interim order?
No, there's no interim order, my lord.
So by now they have been in service for how many years?
They are in service for, my lord, since 2022, 21, my lord.
So the law of equity will also favor
My
them.
lord. No, that is the reason why they are here, my lord. They have been implemented as respondents, my lord. Because if, my lord, if I am successful tomorrow, my lord, in pursuing my lord, and my lord sees that on face of the records and compilations that I will be trying to make, my lord, if my lord is convinced that there is something wrong, illegality has, then it must go. No equity.
That
then.
aspect, of course.
Yes, my
If
lord. So
they have
therefore,
been-
my lord, if my
if they have
lord,
been appointed illegally, then
yes. So if my lord allows me, then 3 weeks time, I'll
Yes,
try
Mr.
make endeavor, my lord.
I think let us get those.
Lordship, yes, because he has made a general allocation, your lordship, where there is no specific, without any specific keys, your lordship.
Exactly.
Lordship, he has to cross the hurdle also. Lordship, as per the code of mark, your lordship. Code of mark is 200 for in case of tribal. He has to cross that to challenge the selection process, your lordship. Lordship, this the code of mark in case of tribe, in case of shield tribe, lordship is 200, your lordship. They fail to secure that code of mark, your lordship.
Maybe what Mr. Yovin said is they fail to qualify to even secure that cut-off mark.
Yes, your lordship. How can they maintain the repetition, your lordship?
Well, that is also another aspect.
How can they maintain the repetition, your lordship?
No, my lord, we can open that part, my lord. We can argue because I can satisfy my lord in that part because I am not asking. I'm not asking terminate him. I'm more qualified and give me straight. That's not my prayer, my lord. My prayer is challenge to the entire process.
If you are not asking for termination of those who are already appointed, then where's the scope for your appointment?
My lord.
In one post, 2% cannot squeeze
no, it cannot. It cannot, my lord. No, if that is marred, the entire process is marred by illegality, then the new entire process needs to restart, my lord.
Whatever the case may be, Mr. Yovin,
Yes.
what Mr. Shulai said is, you see, has a basis.
Yes.
First, you have to satisfy this court that you have qualified.
Yes.
You have qualified. I was under the impression that you have qualified since you said
No, your lord.
that even for the typing speed, you have crossed that 30%.
Yes,
30 marks.
that is there, my lord.
Okay. But then maybe in the other portion, as perhaps written
Written test,
examination,
your lordship.
written tests you have not crossed. So, all those things have to be taken into account.
My lord, let me bring out a chart first, then, because then that will make it very clear, my lord, where I stand,
You
my lord.
satisfy this court as to
Yes, my lord.
whether you are qualified or not in
Yes,
the
my
first
lord.
place. And in spite of being qualified,
Yes.
you have been
Yes.
put at a disadvantage because of
Yes.
these factors.
My lord, my lord. I'll do that like that, my lord, because once that, as my lord have fallen down from my lord, that will make everything clear, my lord. Because it may happen that I secured more than some of the candidates.
Maybe. So,
May.
So that
My lord.
comparative table has to be.
My lord, I'll make a chart of that, my lord. Yes.
Please. So how long?
3 weeks, my lord, because it's an old case. I don't know till how far we can do it.
Mr. Piobin, under counsel for the petitioner, has commenced his argument, but could not complete the same. Since in the midst of the hearing, the learned counsel has sought for time to allow to file a comprehensive table and to prepare a chart so as to enable this court to understand the case of the parties herein. As prayed for, this is matter of 3 weeks.
Mine, 2 weeks. Mine, obliged.
Item number 2.
Yes.
Lordship, on last occasions, Lordship query was if I have not challenged the point of law during trial, can I challenge it later stage? Lordship, I have one judgment which I have, Lordship, I have stated. Yeah. Lordship,
Just a moment.
in this judgment, page number 19.
Just a moment.
Can I have the citation, please?
It's AIR 2021 Supreme
Just a
Court.
moment. Just a moment.
3673.
AIR
AIR 2021 Supreme Court 3673.
3673. Para?
Para, it's page number 19, Lordship, last, para 59. Sorry, 39, Lordship, sorry, 39.
Can you just run? This is judgment you have given?
Yes, yes. No, not this judgment is.
Itu mendek itu kaki sih. Itu mungkin. Kembali kan? Where's that?
Lordship. I gave it to her just now, Lordship.
Just now?
Yes, Lordship.
This is AIR 2011 SC 665. Not this one. Tan. Yes.
Lordship, page number 19, Lordship. Last para.
Para?
Para 39, last paragraph. Para 39, subpara 5.
Just a moment.
May I, Lordship?
Just a moment.
What is this?
Para 39 5.
Yes, Lordship. 39 5.
Yes.
Though the though the appellant did not assail the finding of the trial court on the issue of jurisdiction before the High Court under Order 41, Rule 22 CPC, either by filing a memorandum of cross objections or otherwise, he is not precluded from raising the argument before this court. This court is of the this court, in view of its plenary jurisdictions under Article 136 of the Constitution, read with its power to do complete justice under Article 142, can entertain new grounds raised for the first time if it involves a question of law, which does not require adducing additional evidence, specifically one concerning jurisdiction of the court, which goes to the root of the matter. So, Lordship,
this you read it carefully. This is the power available only to the Supreme Court,
Lordship, but
not to the High Court.
Lordship, I'm coming to this, Lordship. Though the power is conferred to the Supreme Court, but Lordship, question of law can be raised at
Yes, that is fine.
question of law can be raised if it is not raised in the trial court. So my appeal has come as a question of law. My submission before Lordship is based on question of law. Now, Lordship, may I have the act, Lordship? The act.
Yes.
Lordship, Section 11 of the Act, Lordship, is enquiry and award by the collector, Lordship. Now, why I have stressed on that award is very important, Lordship.
Yes.
Enquiry and award by the collector. My point is 11A, Lordship.
Yes.
11A. May I, Lordship? The collector shall make an award. May I, Lordship?
Yes, ma'am. A.
11A, Lordship. May I?
3, 4. Oh, capital A.
Capital A.
Yes.
Yes, Lordship. Period within which an award shall be made. The collector shall make an award under Section 11 within a period of 2 years from the date of publication of the declaration, and if no award is made within that period, the entire proceeding for the acquisition of the land shall lapse. So now, Lordship, here the notification, the declaration was passed on 7/9/2006. Declaration, it is, if paper book is there with your Lordship, annexed to page number 33.
Yes, ma'am.
If paper book is there, Lordship. Page number 33.
Yes.
It's
This is the declaration.
It's declaration. Declaration is point number 3, 7/9/2006, and the award is made on 19/10/2009, Lordship.
This one.
Uh,
This one.
Declaration is now point number 3, Lordship. In page number 33, Lordship, declaration is point number 3.
28/9. 28.9 or
28.9 is notification and declaration is 7/9/2006, published in Meghalaya Gazette on 28/9/2006. It's a declaration 7/9/2006, published in Meghalaya Gazette on 28/9/2006, most particularly on September 2006.
yes?
So, Lordship, and the award is passed on 19/10/2009, Lordship. Here, 2 years' time has already elapsed. It's 3 years' time. Award is passed after 3 years, Lordship.
Award pass.
Award passed 19/10/2009.
Where is that?
The affidavit, additional affidavit, award is there in the additional affidavit. So award is passed on 19/10/2009. So if 19/10/2009 is award is passed and declaration is on 2006, so 6, 7, 8, by 2008 award should have been passed. If 2008 award is not passed, then as per this act, the entire proceedings of acquisition of the land shall lapse. So DC has no jurisdiction only now to send the reference, Lordship. DC, if reference is sent after the lapse of that, if he ceases to have the power, entire land acquisition process is lapsed, means he ceases to have the power. So if he ceases to have the power of that, then of the land acquisition, then sending reference before the court is beyond his jurisdiction, and there is no condonation. Entire act, there is no condonation proceeding. The act does not say that the condonation can be drawn.
There's no provision for condonation.
There is no provision for condonation.
Or okay.
So if the entire proceeding is null and void, Lordship, then the judgment is always is also null and void, Lordship. So if the judgment is not null and void, Lordship, can an appeal lie in this, Lordship? Whatever the proceeding has gone in the trial court, it cannot be taken up also, Lordship. So if the award had the award been part of record during that time, the court would have come to the findings that section 11A is not complied. But if that is why my appeal says that award has to be part of the record, because unless and until award is not part of the record, these findings cannot come. Either the court or the council will come to know only when the award is on record. Otherwise, who will challenge the award? So that is why, Lordship, I pressed on that award has to be on record. Unless and until the award comes on record, the case goes null and void. Lordship, further, while making the award, this is, Lordship, in this case, Lordship, para 12, Lordship.
This is AIR 2011.
AIR 2011.
SC. Supplement.
625.
625.
625. May I, Lordship?
Yes, madam, your colleague is not here.
Lordship, I am appearing online.
You are appearing online, but somebody has to be here. If copy of relevant judgment or any papers is to be given, somebody has to be here. You do have your colleagues with you from time to time, but I don't know why.
Lordship, I'll just try and figure out if someone's there. Ask my team.
Anyway. Please continue.
Lordship, in para 12, Lordship, page number 7.
Para 12.
12, page number 7, Lordship.
Yes.
Lordship, here one citation is there. Just after the citation, the following factors must be etched on the mantle screen, Lordship.
Yes.
For under quotation, Lordship. Yes, Lordship. Reference under section 18 of the land acquisition is not an appeal against the award, and the court cannot take into account the material relied upon by the land acquisition officer in his award unless the same material is produced and approved before the court. So also the award of the land acquisition officer is not treated as a judgment of the trial court, open or exposed to challenge before the court hearing the reference. It is merely an offer made by the land acquisition officer, and the material utilized by him for making the valuation cannot be utilized by the court unless produced and proved before it. It is not the function of the court to sit in appeal against the award, prove or disprove its reasoning, or correct its error, or affirm, modify, or reverse the conclusion reached by the land acquisition officer as if it were an appellate court. The court has to treat the reference as an original proceeding from before it and determine the market value afresh on the basis of the material produced before it. Subsection 3 of section 18 of the Act added in Maharashtra, providing that the land acquisition collector shall be deemed to be the court subordinate to the High Court, is therefore only for the limited purpose of enabling revision under section 115 of the Civil Code to be filed against the order of the collector under section 18, and not for other purpose. Now, Lordship, come to para 14, Lordship.
Para 14.
Lordship.
Yes.
Lordship, the High Court has lost the sight of the schemes of the Act. When land is acquired, the land acquisition officer makes an offer on behalf of the state government in regard to the compensation. The offer made by the land acquisition officer is not an adjudication of the market value or the compensations payable to the landowners. When such offer is made, the landowner has the choice of either accepting the compensation in full and final satisfaction, or to seek a reference to the civil court for determination of the amount of compensation. Where the landowners does not seek a reference within the time specified in section 18 of the Act, he is deemed to have accepted the award, and the award of the land acquisition officer attains finality under section 12 of the Act. Section 18 of the Act enables the landowners or person interested to make a written application to the collector requiring his objections to the award. His objections, on what ground he is objecting, to be referred for determination by the court. In the application, he has to state whether his objection in this is in regard to the measurement, quantum of compensation, person entitled to compensation, or appointment or apportionment. He is also required to state the grounds on which the objections of the award is taken. But the sections does not require the landowners, while seeking a reference, to specify the quantum of compensation demanded by him. Section 18 merely requires a landowners who has an objections to the amount of compensation awarded by the land acquisition officers to require the matter to be referred to the reference court for determination of compensation by specifying the grounds of objections to the award. So the award which through additional affidavit has come, it also does not state on what grounds the objection, the reference has been made. It does not specifically say. Now further, collector's statement to the court. Now section 19 states about the collector's statement. Making the reference, the collector shall state for the information of the court in writing under his hand the situation and extent of the land with particulars of any trees, buildings, or standing crops thereon, the name of the persons whom he has reasons to think interested in such land, the amount awarded for damage and paid or tendered under section 517 or either of them, and the amount of compensation awarded under section 11, the amount paid or deposited under section 3A or 17, and if the objections objections be to the amount of compensation, the ground on which the amount of compensation was determined. To the said statement shall be attached a schedule giving the particulars of the notices served upon and of the statements in writing made or delivered by the parties interested respectively. Emphasize supplied. When the reference is received, the court cause notice specifying the date of hearing for determining the objections of the landowners persons aggrieved. The reference court has to call upon the claimants to file their statement of the claim and call upon the collector to file his objections to the claim statement and then proceed with the matter. Where the application under section 18 contains the necessary particulars, the reference court may treat the application for reference under section 18 and the collector's statement under section 19 of the Act as the pleadings. The landowner is entitled to specify amounts claimed by him as compensation and the heads of the compensations for the first time in such claim statement before the reference court. He can also file an application amending the claim. He is not permitted after the expiry of the period of limitation specified in section 18 of the Act in changing the nature of objections from one category to another. If the reference has been sought with reference to the objections to amount of compensation, the landowners cannot, after the period of limitation, seek amendment to change the claim as objections to measurement or objections to apportionment. Here, while filing an objections, they have never challenged also under what ground they are challenging under protest under what ground. The judgment or the Act has specifically stated that the claimant or the landowners has to specifically state under what category their objection to the award is. But in their objections to the collector, they have not stated anything. So suddenly, if their objection is is not specific, they cannot come to the reference court and say a specific amount that under protest I have claimed under protest, and now my compensation towards, I am challenging compensation towards building or challenging compensation towards land. They cannot directly come and say. They need to challenge it before the collector or the land acquisition officer. Now in these two aspects, whatever I have raised, these two aspects is mainly that the claimant does not have any rights, because more particularly 11A expires. After the expiry of 11A, collector does not have any right. Collector ceases to have the power to send reference, and thereafter whatever has been the proceedings has been proceeded, it all lapses because of the first section 11A. If the absence of award, the court was not aware of regarding the award or the quantum of the land acquisitions officers, the award and under what category, what his finding was, the court was in absentia, court has passed the order. Now if this is so, then can the proceedings pulled on, or can they raise such things now, the claimant? Answer is no, Lordship, because once everything has lapsed, the entire proceeding has lapsed, nothing is survived, Lordship. That's all from my if anything comes up, Lordship, I'll reply to it.
Lordship, are we given a short date to respond? Or if unless Mr. Chen wants to respond.
Mr. Sen, you finish your
Yes,
argument.
the thing is, this is something new for the first time today. It's not a part of their original memo of appeal. This ground that they're raising, that there has been a lapsing under 11A, this has never been raised before.
Okay. Oh.
Today, for the first time, this issue has been raised.
Point of law can be raised at any.
I must be informed. I've come prepared on a completely different point. I'm taken by surprise today that they're raising 11A.
Yes, yes, yes. You should not.
And 11A, Manoj, if I understand correctly, even if there's a lapsing, it should be raised by the beneficiary, the landowner. In this case, they are the beneficiaries. So what happens? The property is now divested. It's the ownership is now vested with the government.
If it is a point of law, it can be raised by any party.
But it's been informed to me last day.
No, that is a different thing. Yeah, of course, you have to inform.
May I just point out what is the consequence? So the land has been taken over
No,
by the requiring body.
would you like to reply today or?
Sometime. Anyway, Manoj, kindly consider this. Land has been taken over by the requiring body. They've already constructed the highway. Now they said proceedings have lapsed. Very well, proceeding has lapsed. What is the consequence of it?
Exactly.
They have to give that land back to the owners. It's not really helping their situation.
Not
Now
exactly.
I will have to give the land back. They cannot retain it. They cannot retain the benefits of the acquisition proceedings.
So you explore the law in that regard as to what would be the consequences. So as let's put it this way, so that the situation can be saved. But the fact that you have to keep in mind that these are, you see, projects which is meant for
Public
purposes, and the interest of the public or society at large has to be kept in mind.
They can't enjoy the benefit and put the entire onus or blame on the DC. They've taken over the land. They'll have to now hand it over. They'll have to hand it back to the landowner. So the original argument that the award has to be attached, they're not pressing that argument. And I think number two, there was an argument with regard to limitation. They're not pressing that argument today. So now what remains is the question of 11A. I'll explore that. I'll examine.
After Mr. Sen completes his argument, then you can give a comprehensive reply, because since you are the appellant, you will post this matter after a week? 1 week?
1 week. Or should I give a date? If it's
You can suggest a date.
When is a Tuesday or Wednesday, Lordship? 17th or 18th?
17. Can you take me? Huh? Yeah, Heard Miss P. Sadi Leonard, counsel for the NHAI, who has concluded her argument. Mr. S.N. Leonard G.A., appearing for the collector, has sought for some time to reply. Accordingly, as prayed for, this is matter for further hearing on 17.
I think 10 also, Lordship.
Yes, same order. Same order.
Obliged.
Item number 5.
Senior counsel is coming this. These are the missing pages.
Just give me a writing for missing page.
Yes.
So, Lordship, my senior is just on the way. He's here.
But I'm sorry, madam. My lord, in the last occasion, substantially I have advanced my argument. I will conclude my argument today.
Yes.
Just recall, my lord, the issue is a promotion to the post of a managing director, MITC. And last time I have shown, number one, there are two sources for appointing to the post of managing director. One is from outside the corporation. When they resort to outside the corporation, the question of seniority doesn't arise. They can pick up anyone And second source is lifting from the corporation employees, themselves, officer from the corporation. Once they lift from the corporation officer for the post of managing director, they have to follow the rules. Number 2 is that appointing authority is the governor. We're not disputing that one. Number 3, my lord, the basis for promotion is on the basis of the ACR. We can say merits come seniority. Now, admittedly, the record shows that, my lord, there is no ACR prepared since the inception of the corporation itself. There is no assessment, suitability of the candidates. So what is left behind is the seniority. Now, in view of that absence of ACR preparation, all throughout, whenever governor lifted the officer from the corporation, they always follow this industry seniority. Even 1 day senior, 2 day senior records are there, they always appoint the senior most one. There is no single officer from corporation who was junior and yet appointed as a managing director over and above the other senior. This is the only.
That is the precedent.
That is the precedent. That is the practice followed by the corporation throughout. Now, before I show the rule, last time I've shown, my lord, to the Articles of Association. I'll go to the rules, but before I go to the rules, my lord, I would invite lordship attention to the affidavit filed by the government, by the respondent. I will, my lord, invite my lord to see.
Yes.
My lord, the affidavit which they filed, jointly filed by respondent number 3, 4, and 5, my lord, dated to 27 July 2022. Subsequently, they have also filed a separately supplementary affidavit. And I would, my lord, the contentions are more or less the same. So I would go to, my lord, to save lordship time, to command affidavit filed by respondent number 3, 4, and 5. 27 July 2022.
2022?
Affidavit in position, yes. They have made.
Is it 23 or 22?
It should be, my lord, 2023. 2023. It should be June, my lord, the month of June 2023.
Yes, June, that's what
Yeah,
it is.
well.
You said July.
Well, so I would show, my lord, para 9. The basic contention I would show, and I'll go to the rules. Para 9, Roman 1. It says the post of MD of MITC is not the post that can be filled by promotion on seniority basis from amongst the officers of the corporation. It is a post of appointment made by the government from time to time as they deem fit. They say here, my lord, at times the government may select from among the officers of the corporation if it feels that they are fit for the post. Otherwise, even if they are senior manager, general managers serving the corporation, the government, as per the Memorandum Articles and Association Corporation, has the liberty and authority to appoint any individual as a director in the board of directors, and from the directors, the government may appoint any director as the managing director of the corporation. That is true, my lord. That therefore we say there are two sources. They can appoint any person outside the corporation. It's up to the government. Senior IAS officer, they bring from the Commerce Department or Agriculture Department, put there as a managing director. That's outside the corporation, outside the service rule. But they used to appoint the officer from the corporation. So when they appoint officer from the corporation, there is a service rules. Service rule. It seems that the way they project, my lord, it is unguided regulation, unguided powers they exercise.
So in service, appointment is usually by promotion.
Promotion. I'll come to that, my lord. Therefore, I want to say that the way the respondent project, that it seems the government has unguided powers to appoint. This is not. Outside the corporation, they exercise at discretion. But when they want to lift from the corporation officer, service rule governs. Now, number Roman P2, my lord, the board of directors can constitute by the government has all the wisdom, liberty, and authority to recommend any officer who the board may feel suitable for the post of managing director. Now it says, board of director has the power to recommend. Under the service rule, there is no even Articles of Association. Board of directors is not the recommending authority. But here they claim they have the liberty, the wisdom to recommend. It's absolutely wrong. Now, may I come to the last portion, last portion paragraph. The petitioner joined the corporation as a probationer as two other deputy general managers. Therefore, seniority was not counted during the probation period. I'll come to that one. He was appointed as assistant manager in June 05 on successful completion of the probation period. The seniority as per the service rules of the corporation is counted on the day when all the three then assistant managers, including the petitioner, were regularized. Now, they say minority may just pause it. May complete. Therefore, under no circumstances, the petitioner can claim to be senior to the two existing deputy GM. It says that the regular service seniority will be counted from the day of regularization. I'll show the rules. It is not. The rule didn't say so. Now, I will come to para 11. Well, the government made in para 4 of the writ petition that the answering respondent 5 has misinterpreted the facts and manipulated the board to go for a candidate with additional qualification as against the convention of recommending the senior most qualified candidate to fill out the post of MD with modified intentions totally incorrect and unfounded. In fact, it says, answering respondent has apprised the board of the date of appointment, date of joining, date of regularization, and subsequent promotion and regular vicia were presented to the board of all the DGMs, and there is no iota of proof that respondent number 5 had misinterpreted the facts and manipulated the system in advising the board to recommend a candidate with the additional qualification with the modified intention in favor of respondent number 4. So respondent number 5, there is allegation that he was the one who modifiedly processed the file. So that is his response. He says, my lord, therefore his contention is that, my lord, he did not commit any resort to modified action. Now, number 12, my lord, it is submitted that the senior most deputy general manager have no legitimate right to claim promotion to the post of MD. Now, I come to number 14 straight away, my lord. But in this regard, the government made para 10 of the petition. It is stated that answering the respondent number 4 had no occasion to raise the issue of seniority as the subject of seniority or never came into consideration, and answering respondents along with other deputy DGM were always of the opinion that they were all equal in rank since regularization subsequent promotion, and the pay scale of all the DGMs were all the same as they were regularized after their probationary period. No one dispute, madam. All of them are equal in rank. All of them are in DGM rank, equal in rank, madam. Now, the other part, madam, it may be mentioned here that the other two DGM have never recognized or treated the petitioner as being senior to them, since there was no communication from the management to the other DGM that the petitioner was senior to them. Hence, the question of a dispute on seniority being raised by them does not arise. They say, my lord, they say that since the government the corporation did not communicate to these two gentlemen that I'm senior to him, senior to both of them, I'm not senior. How can it be, my lord? May I come to this, it is important, 15 is important, my lord. Paragraph 5 of the writ petition is total and founded in as much as respondent 5 has never manipulated the system in advising the board, as there is no evidence that respondent number 5 had suppressed any information either of the petitioner or the other DGMs, as can be seen from the agenda presented before the board. The board was presented with the actual records of service and qualification of all three deputy general managers, and the board, which is the authority to decide on the functioning of the corporation after diligently examining all aspects, had already only expressed its opinion that the respondent number 4 seemed fittest for the purpose of position of taking the corporation onward. However, the board did not recommend only the respondent number 4. Instead, it has instructed the management to send the names of all three DGMs to the government for further examination and to pass order for appointment for the post of managing director. Now, in one paragraph, they say, my lord, I did not challenge the recommendation. Therefore, I say that was not the recommendation. And now they admitted that it is not a recommendation. It only all the three names were instructed. So the question of challenging that file, or so-called the recommendation, is also not right. Therefore, in the last occasion, I say that that paper, that record, do not confer any right to any one of us. Forwarding the three names. Now, Lordship would only examine on what basis the governor, the government appointed, on the basis of what qualifications among three of us lifted the respondent number 4. That is the only issue. Now, they have admitted that they never recommended one person. If they recommended only one person, number 4, I could have challenged that one. But since the three names were forwarded equally, so the question of challenging doesn't arise. Therefore, the plea taken by the respondent state that not challenging the recommendation is fatal to my petition, absolutely wrong. So now, may I come to, they have highlighted, my lord, para 21, page 9.
Yes.
And I would show, my lord, the table they show. Appointment of a managing director, page number 10. Now, SP Kurung, Director of Industries, he was appointed from the outside the corporation. He's outside. Now, number 2, J.R. Merpo, he was from inside the corporation, and he was the senior most. Therefore, he was appointed as a managing director. Now, number 3, F.K. Chakraborty, he was from the outside. So, service rule doesn't apply. Seniority doesn't apply. And number 4, my lord, Yesum, well, he was also from outside. And my lord, H. Kindia, he was from the MIDC. He was appointed later because he was the senior most. And Mr. B. Langstang also from outside. S.F. Pengrup, he was from the corporation. He was one of the senior most. Therefore, he was appointed. And my lord, P.M. Sheila, he was also from the officer of the MIDC, the senior most. And Marpaneng also from the senior most. Therefore, they say that they don't dispute. And Ms. F. Sotunga is from outside. And G. Gindia also MIDC, the senior most. I will show their appointment letter. Therefore, if I can show their appointment letter, these people, may just Lordship will drop attention to. I would invite my lord to come to page number 72 of the petition.
Yes.
Once then, they have mentioned serial number 4 HK in there, the one we have I pointed out in their affidavit. Serial number 4, my lord. HK in there. Date of joining, my lord. 01/10/1977. And his colleague, contemporary colleague, Mr. P. Ruram, was joined on 4th October 1977. Only 3 days difference, my lord. And because of that, my lord, H. Kenda was appointed. That is one, my lord, one instance. If I can go to other, my lord, page number 73, PPSF Bank Group, since they have mentioned their affidavit, I'll clarify this point. Page 73, at the bottom, my lord, serial number 8, my lord. SF Bank Group, date of joining is, my lord, 01/02/82. Yes. And his contemporary PM Sheila, who became later, my lord, his date of joining, her date of joining was 032. Only 2 days difference. And because of the when vacancy arose, SF Bank Group was appointed. Not because of other additional qualification or other consideration, only because of the seniority. Now, all throughout, my lord, all throughout, the appointments are there from page number 74 onwards. These are the appointment letter of these gentlemen. Therefore, there is no single material shown by the respondent that they have appointed a junior officer from the MIDC to the post of managing director. And I would, my lord, I would show, my lord, page number 23 of the petition, the regularization. Since I'll go to the, my lord, 23. Regularization of the probation.
Yes.
My lord, it says, Sri Rigrak Sage Moment on successful completion of his 1-year probation period on the 6th June 05. He is hereby appointed as the assistant manager in the office of the MIDC in scale of such per month plus allowances as admissible under the rules of the corporation currently in force with effect from 1st June 2005, subject to the following terms and conditions. So he was joined, my lord, he was joined in service on 7 June 2004. And after 1 year completion, he had completed 1 year probation on 6 June 2005. Therefore, he was confirmed with effect from 1st June 2005. The two gentlemen, my lord, joined on 14 June 2004. They were completed the 1 year probation on 13 June 2005. Date of confirmation. Date of confirmation was different. But since the petitioner has joined earlier. Now, my lord would come to see page number 47. 47. This is a service record prepared by the MIDC.
Yes.
Now, my lord, respondent number 4 in the writ petition, my lord, his name is my lord Eliniti Nongmali. Date of joining serial number 2. He was joined in the service on 14/6. And another gentleman, Lepson Sangma, also joined on 14/6. Writ petition joined on 7/6. Now, these two gentlemen, they were also confirmed, completed the 1 year service on 13 June 2005. So, date of confirmation was different because of the different date of joining. Now, I'll come to the service rule now. Service rule we have next in the rejoinder. Service rule is available page number 51 of the rejoinder affidavit. We have the next.
Rejoinder dated?
Rejoinder dated, my lord.
Rejoinder to?
Rejoinder to the respondent number 1 and 2.
1 and 2.
Which we have filed on 27 July 2023.
Yes.
Now, therefore, my lord, the brief substance of the counter affidavit filed by the respondent is that they can appoint anyone. If that be the case, if the board of director governor is satisfied, they can appoint grade 4 also to the post of managing director. Number 2, my lord, seniority doesn't matter. Number 3, my lord, seniority doesn't count from the date of joining, but date of regularization, confirmation. These are the basic 2-3 reply. My lord. Let us see the rules, my lord. Start from, my lord, page number 55. They say that post of director, managing director, is not a promotion post.
Yes.
As if it is not a part of the MIDC. In fact, he is the head of the MIDC. Page number 55.
Yes.
Definition of employee is also mentioned there. 301. I will not read, my lord.
Yes.
Then, my lord, the next page, 56, 307, definition of managing director given. Managing director in relation to any powers exercised by him includes any director or officer who is authorized by the board to exercise the power and function of managing director during the temporary absence of the managing director. Service include, my lord, managerial level is important, my lord. 311.
Yes,
classification, my lord. Managerial level employees in the categories of assistant managers and above is deemed to constitute managerial level. These are higher officers, my lord. Lordship kindly say managerial levels started from assistant managers and above. Above reach till the top post, that is the managing director. Now, classification, my lord, 4. There shall be a following classes for the employees of the corporation. Class 1, 2, 3, 4.
Yes.
And class 1, when all employees drawing pay in scale of rupees such and such and above. But assistant managers above draw these salaries and above. And managing director also draw higher than this.
Yes.
Now, permanent employees, my lord. 5.1. Permanent employee means a whole-time employee whose appointment has been confirmed by board and includes an employee who has satisfactorily completed probation period in the corporation, and also those employees who were working in a permanent capacity before enforcement of this order. So there is a permanent employees. So the question is, my lord, whether the post of a managing director is a permanent post or not. Is a permanent post. I'll come to that, my lord. Permanent post. Now, probation, my lord. Probation, my lord, probation is there. May I come to the next page? Appointment, probation, confirmation, my lord. Now may I come to appointment. 6, my lord. Power to appoint. All appointments to the service of the corporation shall be made by the managing director, provided that no person shall be appointed as an officer unless his appointment is first approved by the board. Preference for such appointment shall be, however, be made from amongst the existing employees. So all the appointments except the managing director is appointed by the managing director. Managing director is the appointing authority, subject to approval of the board. So governor can only appoint the post of the managing director. Now, qualification by lot 603 qualifications. Candidates with degrees in engineering or postgraduate degrees in general discipline or business management, chartered accountancy, course accountancy, diploma holders with 7 years experience in similar lines of activities, or as decided by the board from time to time, would be considered for appointment as a management trainees, depending on suitability, preference, and such. So it is given there, madam. The qualifications, madam.
This is not in dispute.
Not in dispute. All of us has a qualification. Now, may I come to 606, madam? Commencement of service is important. They say the commencement of service start from the regularization. My lord, can kindly see. 606.
Yes. Yes.
My lord. Except as otherwise provided by or under these regulations, service of an employee shall be deemed to commence from the working day on which such employee reports for duty in an appointment covered by these rules at the place and time intimated to him by the managing director, provided he reports before noon, otherwise his service shall commence from the next following working day. Now, therefore, the commencement of the service start from the day of joining report. I received the appointment letter today, but if I join tomorrow, my service will commence from tomorrow. If I join next week, no matter I receive today, my service will commence from next week. Now, it doesn't say so.
I think in service law that is common.
But therefore, the affidavit say that service rule, seniority will be counted from the day of regularization. Therefore, I am giving reply to this.
My apologies for interjecting, my lord. Now, my friend is relying on an affidavit, my lord, which has already been recalled. The affidavit which was jointly filed by respondent number 3, 4, and 5, my lord, has been recalled. Now, the order recalling, my lord, is. My lord, the order recalling that affidavit is 22/4/2024.
They were allowed to file a supplementary.
Yes,
they filed jointly earlier.
Rely
Therefore,
on
we
the
raised
supplementary
the
affidavit. This has
issue.
already been recalled.
We raised the issue. Therefore, they were allowed to file.
No, what he at present he is on his rejoinder.
My lord, initially when he started his argument,
That you could have.
he was relying on
Okay.
an affidavit which has already been recalled. So
My lord.
whether rejoinder will suffice, my lord.
My lord.
On an affidavit which
So this is rejoinder to affidavit of respondent
My
1 or
lord,
2.
my lord, can you see your lordship order dated 2nd April 2024? There is no recalling order.
No, my lord. My lord will kindly
Yes, absolutely
take notice of the order dated 22/4/2020.
My lord, can you see first 2nd April also there is also order.
I am
Prepared by Senior Council.
24, my lord, 2024.
Okay, let us see together that one also. Madam, for lordship, can you see 02 April 2024?
20?
2024. That they were allowed to file a supplementary affidavit, and they file accordingly.
That has been filed.
But at the point of Mrs. Sons and learned senior counsel assisted by Sons and learned counsel appearing for the respondent number 1, 2, 3, 4, 5 submits that the earlier affidavit has been filed inadvertently and prays that she may be allowed to file a supplementary affidavit. Considering the name, the prayer is allowed. So on this day, my lord, she was allowed to file a supplementary affidavit. And they filed. And subsequently, my friend referred.
So, okay, let's put it this way.
Yes.
See, the joint affidavit that was filed by 3, 4, and 5 was recalled.
Yes.
Subsequently, they have filed the respective.
Respective affidavit. Yes. Okay. That also, my lord. Since but substance are the same, therefore I pointed out. No. I pointed out. I can take the lordship attention to that also.
Affidavit has been recalled. How can
Yes, of course.
But
You should have.
What's the specific? My lord, in that case, my lord, let me refer to the affidavit filed by them, individual affidavits. Yes. It's the same. My lord.
You should have done that.
I'll come to that, my lord. I'll come to that.
Okay, substance may be the same, but.
My lord, I'll show that. Lordship permission. My lord, may kindly see the affidavit, supplementary affidavit filed by 3.
Let's complete your rejoinder first. Or this is rejoinder to 1 and 2. So
rejoinder
as far as 1 and 2 is concerned, there's no.
We have rejoinder. Rejoinder was filed with regard to this also. We have filed the rejoinder. My lord. So if lordship kindly see the first affidavit filed by individual
now,
respondent.
Have you completed with your rejoinder? This
Even
6.06.
since my friend pointed out that the supplementary affidavit they filed, well, I will show their contention. I'll show their contention and come to the service rules with lordship permission. Otherwise, I would show the contention of the same. Anyway, my lord, I would show, since it is recalled in form. I agree with the record, is recalled. Subsequently, I was not aware. Now I'm aware now. The affidavit filed by them individually. My lord, I'll show, my lord. That is, first affidavit is filed by number 3. R3 is on 22nd April 2024. Supplementary affidavit. Well, if I may take a para 9, all is the same. Para 9 also more, it is the same, lifted from the old one. I will not read again.
Who is 3?
Number 3, my lord.
Number 3 is the MITC.
MITC.
I am going to show number 4. The present.
3 is the MITC. 4 is the appointee, my lord. Number 5 was the outgoing empty. Outgoing empty. Number 5. Well, we can see para
just one.
Yes. Para 9. The same. Para 9:15. The one I read out, my lord, the same.
Para 9.
Para 9:15, my lord, I have read out earlier, my lord, is the same. Para 21. The name of the appointees, previous appointees, same thing, my lord. Para 21, they show the same officers.
Contents are the same, you will see.
Contents are same. And then, my lord, the state affidavit, that is the MITC affidavit, and state affidavit with lordship permission can I show, which they have filed on 12 July 2023.
State affidavit?
State affidavit, number 1 and 2, which they have filed, served on us on 12 July 2023. Was filed by Mr. Friday Sudunga, Director of Commerce.
This one.
Lordship called it.
Yes, sir.
Madam.
This is 12 July.
Madam, 12th July 2023. Filed by Mr. Friday, Director of
Friday,
Commerce.
Sutanga.
My Lord. And may I just come to, my Lord, page number 4, para 4, Roman 4.
Just a moment.
Page number 4. And Roman 4, para 4 at the bottom, my Lord. They have stated it is further also noteworthy to state that no challenge has been made to the decision of the board meeting dated such. It is only when respondent number 4 is selected and notified as the new managing director, the petition has raised the grievance of arbitrariness after voluntarily accepting the entire procedure and also refraining from pressing or enforcing his right when they highly unwarranted and uncalled for. They are saying that the so-called the forwarding of the name, selecting three of the mentioning to all the three names. They said I should challenge it. They said this is a recommendation. Madam, that is not a recommendation, madam. And that doesn't confer any rights to any one of us. All the three names were there. If only single person, number 4 name were recommended or forwarded, I could challenge it. But all the three names, officer's name were forwarded. And now, my lord, page para 8. In the middle, it is pertinent to state that based on recommendation and as per the Article 62 of the Articles of Association, as appointed in the past without referring to any ACRs or seniority. Para 8. Page 5.
Yes.
Madam, in sub-para, madam. In the middle, madam.
Okay, pertinent.
It is pertinent to state that based on recommendation and as per Article 62 of the Articles of Association, has been appointed in the past without referring to any ACRs or seniority as alleged by the petitioner has been as under. Now they admitted there was no ACR, but all the appointees they mentioned here was based on the seniority. I would, my lord, total 22. The next page, page number 6, 22 officers they were mentioned. Out of 22, my lord, 14 were outside from the MITC. 8 were from MITC, and all these 8 were the senior most among all of them. No single MITC officer given the post of managing director. Now, page, my lord, para 12, page number 7. State asserted it is not a promotional post.
Yes.
Para 12, my lord, with regard to the amendments made in para 6 to 9 of the writ petition, the answering deponent states that appointment to the post of managing director not being a promotional post, in the absence of specific notification, scheme, rules, or regulation to appoint the senior most employee of the MITC, the post of managing director, the state in exercise of its authority empowered under Article 62 of such and such has the right to appoint anyone as managing director, and the same has been duly followed in the instant case which is apparent from the incompetency charge mentioned in the foregoing paragraph. Now, what is the basis, madam? If, my lord, there is no rules, no scheme, no regulation, what is the basis of appointing the post of managing director, lifted from the employees itself? Therefore, the service rule is very important. Service rule guided the appointment. Now, my lord, I would refer to the last affidavit filed by number 4, Mr. The appointee. The affidavit filed by him was served on us on 24th June 2024. Well, got it. Affidavit filed by Mr. Delaney, Nongmali. But Para 11, he has given a table naming the officers, some of the officers, madam. Running page 7, madam. Chico Room, also from outside. My lord. J.R. Mirpo.
Para 11.
Para 11, my lord. Page number. The table they have given. The next page number 7.
Yes.
They have mentioned few names of the officer.
Yes.
SP Kurung is from outside. They appointed him. Number 2, my J.R. Mirpo. He was from the MITC. He was one of the senior most.
Yes.
And Mr. Diki Chakrabarti, outside, my lord. And Yesom also outside. H. Kindia, the senior bottom, my lord, senior most.
Yes.
And W. Langstang also outside. FG Peng Group, which I read out earlier, he was also from the MITC, the senior most. Sheila also subsequently. In the last objection, my lord, they said, my lord, at the end of that very paragraph, page number 8, I did not raise the objection of forwarding the 3 names. That is one of the contention.
Where is it?
My lord, at the ending part of page number 8, my lord, in the middle, therefore the government in its own discretion and understanding appointed the ensuing deponent as a new managing director, and the same in respectful submission cannot be faulted with the petitioner at this stage, more so when the petitioner ever raised any objections earlier with regard to the forwarding of the names of the 3 candidates for the post of managing director, MITC. So he has taken that plea. I never raised it. I will show that objection also in my rejoinder with regard to this. My rejoinder I filed on, my lord, rejoinder to the affidavit filed by number 4. I filed on 3rd August 2024, the rejoinder. I filed all the rejoinders, man, against all these affidavits filed by them.
Yes.
Okay. And those, my objection is available in my rejoinder, my lord, which we have filed on, my lord, 27 July 2023, in response to the, my lord, response number 1 and 2 affidavit. And if I can come to that very objection,
I do not have a copy of that objection. I have the copy of the affidavit.
Rejoinder you don't have?
Yes, my lord.
Copy of the rejoinder you don't have?
Copy of the rejoinder I have, my lord.
Yeah.
However, the enclosure is not there.
No, I was referring to the rejoinder.
But
you are referring to rejoinder?
But rejoinder affidavit dated 27 July 2023.
There's no enclosure.
But that respond to the response number 4. There is no enclosure.
Exactly.
But annexure, that is correct, my lord. My friend is looking to the rejoinder to the response number 4. I am looking to the, my lord, rejoinder to response number 1 and 2.
Oh, 1 and 2.
1 and 2, my lord. Well, the mask was created, my lord, because they filed a joint command affidavit.
Yes, sir.
That is the problem. And later on recall and allow them to file separately.
Where's your rejoinder to 1 and 2?
1 and 2, my date is, my lord, 27 July. My friend is correct. 27 July 2023.
27 July. Yes, I think you have referred to this rejoinder.
Yes, we have referred, but since my friend pointed out that one, therefore we jump to other affidavit. Now let us come back to this, my lord.
Now we are coming back to...
We're coming back, my lord. And my objection is my page number 117 onwards.
So,
Filed on 23rd December.
this one. 2023.
Well, 2023, 23rd December 2022.
27/7, isn't it?
117, madam. Page 117.
No, I'm sorry. I'm looking at your agenda, rejoinder.
Yes. Page number, Lordship, may kindly go to page number 117. Annexures.
Annexure 14.
Madam.
Yes.
There also I put in my objection, and earlier prior to that also.
Yes.
And my lord, may come to page number. My lord. What? My lord. It will be 120, my lord. We placed that objection before the authority, MITC, on that day, my lord, in the office since it was not available. And the last page, my lord.
Is this the way to communicate?
My lord, on that day, my lord, he was not available, therefore he placed it, my lord.
Quite novel way.
My lord, there is he could have sent it. Therefore, the last page, annexure, my lord.
Did you WhatsApp to his acknowledgement?
There is no acknowledgement. There is no acknowledgement.
We don't know whose number this is.
But Lordship, mainly is the last page. There also he places a grievance before the board of directors.
Last page.
But in the last second paragraph, my lord, further being the senior most officer as defined and endorsed by the relevant sections of MITC's Employees' Terms and Conditions of Service Rule, I feel it is my duty and responsibility to make my stand clear that the process of recommendation, selection, appointment of candidate as the next managing director be done purely on the basis of seniority and legally viable terms. That is interest of safeguarding sons and sons. So he places he expressed his grievances already.
Yes.
Now may I come to the service rule, which is a very vital one.
Mr. Sarisu, I think we'll continue on the next date. Take up that date. Apa itu? So when do we have it?
Subject to Lordship committee next week or
2 weeks. Heard Mr. H.L. Sangisu, learned senior counsel for the petitioner, who has yet to conclude his argument and will continue on this next day as agreed to by the parties. List this matter up to 2 weeks.
Okay.
Item number 8.
Please, Lordship, this matter pertains to a school teacher, my lord. Only what I wanted to point out is there's a miscase served to me yesterday by one applicant in the name of Sofiqul Islam. It's not listed in the list today for impleadment, Lordship. So perhaps that has to be taken up.
But this is not on record.
Lordship, yes, but this has been served and yesterday.
Yes, yes.
Miscase number 16.
Who's appearing?
It was filed by Mr. Sheikh. I don't know, perhaps because it was not in the list, maybe he was...
It's not on the list.
It's not in today's cause list. So the miscase is not listed, Lordship.
See, miscase
yes,
is connected to the main case.
Yes.
So naturally, if the main case is listed today, then the main case.
Absolutely, Lordship. But he's not here so far as.
on pre-made by parties. List this matter on 16.
Item number 9.
May it please your lordship, the conducting council is on sessional leave. Is on session leave due to death anniversary of her grandfather.
You should have made a mention during mention hour.
My lord, I was in courtroom number 4.
Pre-made by Minister, Learned Counsel. You are also in this case.
Yes.
Are
my
you in
lord.
this case?
Yes, my lord.
You file a power.
Yes, my lord.
On pre-made by Minister, Learned Counsel petition. List this matter after 2 weeks.
Much obliged, your lordship.
Item number 11.
Please, Your Lordship. Lordship, this is a connected matter, Your Lordship, pending before this honourable court, Your Lordship. There's a connected matter, Your Lordship, pending before this honourable court. So I'm praying that this matter may be listed together with the connected matter, Your Lordship. It's coming on
Lordship, what
16.
happened, Your Lordship? This is his bill has been cancelled. He filed this revision challenging that order of cancellation. He was arrested, Your Lordship. They have moved the bill, Your Lordship. That on that day, Your Lordship, when I said that
Yes.
the order of the session has not been closed, Your Lordship.
When is that case?
It's coming on
16,
Monday, Your Lordship.
Monday? Lordship. As prayed for Mr. Letter Counsel for the petitioner, this is matter on 16. Highly obliged, Lordship.
Item number 13.
Give me some time because the lady is pretty old. She cannot come today. We will bring the documents. But without hearing us, without anything, my lord, another eviction order is passed. Now, thereafter, again, we go before the Board of Revenue and we file an appeal. Now, interestingly now, my lord, the Board of Revenue now says that the appeal is not maintainable. Initially, my lord, the same Board of Revenue had made this, the challenge was made before the High Court also. My lord, they fought, the parties fought tooth and nail, saying that an appeal before the Board of Revenue is maintainable. But be that as may, my lord, I will just take lordship to the impugn order. I'll just point out one very technical aspect of the order, my lord, which is, if lordship will come to page 38, this is the order of the Board of Revenue. My lord, kindly see who has signed this order. This is an order of the full bench of the Board of Revenue, which is signed by the Secretary, Meghalaya Board of Revenue.
Secretary or Chairman?
My lord, the Chairman's signature I do not see, my lord, in the certified copy. In any case, my lord, it has to be signed by all the three members. That is what the rules of the Board of Revenue itself provides. My lord, I will just take lordship to this. My lord, rule 26(3)(a). I have just flag mark, my lord, kindly see what it says.
Yes.
Now, my lord, after this order is passed, if I am to read the order, my lord, there is no finding at all. No finding at all. They only said the appeal is not maintainable, appeal is dismissed. Now, my lord, I file a CRP against this. My lord, I have the remedy available to me. I file a CRP, my lord, before this honorable court. I make a mention yesterday itself Today, my lord, the matter came before the board of Honorable Justice Bhattacharjee. For some reason, Justice Bhattacharjee was recused. Now, my lord, now they have gone to demolish to evict me from there. In the meantime, my lord, there is a civil suit pending before the court. Now, what is my case, my lord? Well, what the law says also, my lord, what the Supreme Court says also said, I place the judgments. When a person raises a very bona fide claim and there has been a length of possession, summary eviction procedure cannot be resorted to. What is my claim before the property, my lord? In the year 1985, my lord, the local authorities have given me certain documents. Subsequent to that, my lord, I have also registered a deed of declaration before the sub-registrar's office. I have, in fact, my lord, 10 documents to substantiate my claim over the property. And I have also filed a civil suit. So, in such cases, my lord, the Honorable Apex Court has held, you cannot resort to summary eviction procedure. A person has brought a very bona fide claim, only a civil court can dispute can say who is the actual owner of the property and say whose title it belongs to, my lord. Now, my lord, the action of the state, my lord, in my humble submission, is supposed to be a very model litigant. The state cannot resort to such means. By not giving me enough opportunity even to, my lord, to avail my remedy, sending the people in the morning to vacate me from the premises, my lord, this order is absolutely illegal, my lord, it needs to be stayed. On the very first thing, my lord, that the order has not been signed by the proper person. It is a full bench order of the Board of Revenue, signed by a single person, no application of mine whatsoever, my lord, no finding, nothing at all. And the same Board of Revenue, my friends will agree over here, had at one point of time said that appeal is maintainable. The matter went all the way to the Supreme Court. The Supreme Court also said appeal before the Board of Revenue is maintainable. Now they say the appeal is not maintainable. And the same Deputy Commissioner, which found me to be not an unauthorized occupant, issues notice saying that now I become an illegal occupant. Now, only question here is, my lord, I have so many documents to substantiate my claim. What is the document they have to substantiate their claim over the property? Can the government wake up one day and say this property belongs to me and tomorrow just summarily evict me from the property? Tomorrow, my lord, anybody's property, they'll come and say this property belongs to me. The first notice, interestingly, was issued in the year 2010. I have been in possession of the property since the year 1985. How can the municipality come and claim that the property belongs to me now? The only right forum now, my lord, this is my argument. This was my argument with the Board of Revenue also. In fact, I had submitted a written argument. All the judgments were placed that the only forum now is the civil court where the suit is pending. Let the civil court decide. How can the Board of Revenue come to a finding that this is not maintainable and you just throw me out? That is the case today before, my lord.
Who has filed the suit?
But I filed the suit, my lord. Of course, this should have been filed a long time back. But when the matter came to me, my lord, I have realized that, my lord, there cannot be an express bar to filing any suit because a bona fide claim is there. And there are judgments to support this contention also, the judgments of the Honorable Apex Court. In similar statutes in other states, the court has made it very clear. If you bring a bona fide claim, if there has been a lengthy possession, you cannot summarily go and evict somebody. A summary process cannot be resorted to. Evidence has to be recorded, opportunity has to be given to the parties. No such thing was allowed, my lord. That is my case. In any case, my lord, at least 15 days time should have been given to me. Order is passed on the 5th. We received orders yesterday. In fact, my learned friend will also agree. Even he received the order yesterday. And today they have sent there to demolish when I file a civil revision petition before this Honorable High Court. At least this civil revision petition ought to have been heard, my lord, at least. Absolutely illegal order, my lord. The state is supposed to be a model litigant, my lord. State cannot resort to such means. This CRP should have been heard at least. If it was dismissed, then they could have resorted to, my lord, dispossess me. It is not a case where, my lord, I've been there just for a couple of years. I've been there in the property for the last, my lord, more than 45-50 years, my lord. I'm only praying, my lord, at this stage to stay this, my lord, the operation of this order and my lord, also the order of eviction, my lord. The CRP may be heard.
Where is the order of eviction?
My lord, the order is dated 5/2/2026.
Yes.
Starts at page 34.
So where is the order of eviction?
It's annexure 33, my lord. I'll just point out the page number. (176), my lord. Page 176. And my lord, one more thing, my lord. If lordship will come to page 52, this is the patta issued by the CM of Delhi in my favor.
We will not go into that. Not at this stage.
Lordship.
Yes, who's appearing?
I am appearing, my lord, in this matter. My lord, there are two contentions which have been advanced by my learned friend, my lord. First contention which has been advanced by my learned friend, my lord, is that I have filed a suit and I am in possession of this land. Therefore, the proceedings under Public Premises Eviction Act is not maintainable, my lord. That is the contention, and suit title should be decided. If I have understood correctly, my friend has said, my lord. Now, my lord, this issue has already been settled up to Honorable Supreme Court in this case only when he raised the objection as to the maintainability of appeal, my lord. Kindly see the order of this Honorable Court, detailed order which has been passed by this Honorable Court, my lord, which is at page 121 of this paper book, my lord. Has annexer 26, my lord, at page 128, my lord. I'm sorry, 128. 128 at annexer 16, my lord. Lordship has the annexer 16. The order of Lordship will notice this is the order dated 6th August 2021. And here the appellant files 227, my lord, and first paragraph I will place, my lord, has been challenging the order of 4th July passed by the Meghalaya Board of Revenue, Shillong, whereby it has been held that appeal filed by request is maintainable under Section 8. Main ground by petitioner substantiate his case is that petitioner found to be unauthorized occupant by Revenue Authority, that is Additional Deputy Commissioner, by order of 21st June 2013. Said order has attained finally terms of Section 9 of the Act. Further point has been raised that appeals would lie only in respect of order eviction placed under Section 4 or under 6. It is contended by the appellant that since the order passed by the respondent before the court is not against the order of eviction, such appeal is provided in law and such not provided in law, and impugn order is beyond jurisdiction. My lord, by detailed judgment and order, my lord, this honorable court running into more than 20 pages, my lord, if your lordship will kindly come to page 140. Sorry, 100. This page is some issue is paging. My lord, kindly come to page 141. There are two pages, my lord. 141. 140 and 141, paragraph 17, my lord.
Yes.
In view of the discussion, facts and circumstances stated above, the order passed by Meghalaya Board of Revenue is upheld and appeal against the order of 2013 is held maintainable, accordingly dismissed, my lord. 18 dismissed. Against this order, my friend, my lord, has gone to the Honorable Supreme Court, my lord. Kindly see the order of the Honorable Supreme Court at page 142. 142. At and relevant part, you will also will see 144, my lord.
Yes.
Now, 144, having heard land counsel for the petitioner, we do not find any ground to interfere with the impugn order passed by the High Court of Meghalaya at Shillong, dated 6th August 2021 in present. However, it goes without saying that petitioner shall be at liberty to raise the objection that subject premises is not public property during the course of hearing of the appeal before the board, and such a plea shall be decided in accordance with law, my lord. So, my lord, and then thereafter, what the appellant does, my lord, kindly mark that this is the abuse which they have taken place. Kindly see, they file a suit, my lord. If you also will see that the filing of the suit, my lord, which is at page 152. So 152, the Honorable Supreme Court says whatever 152 is a suit, and the appellant files a suit.
152 show cause.
In view is 152, my lord. After the judgment and order of the Honorable Supreme Court, my lord, your lordship has noted, and after the order of the this Honorable Court, my lord, the order of the Honorable Supreme Court is dated 11th July 2022, my lord. Yes. The suit is filed on 12th February 2024, my lord. So therefore, the plea that I have filed the suit and it is not maintainable, my lord, in my greatest respect to my friend, my lord, to the argument, my lord. this argument is abuse of process of law, my lord. Abuse of process of law, and it is in teeth of the judgment and order of the Honorable Supreme Court. That is point number one, my lord. Point number two, my lord, is that, my lord, there is a bar under the Act itself. Under the Meghalaya, the Public Premises Eviction Act, my lord, it clearly section 14 of the Meghalaya Public Premises Eviction Act, my lord. If Lordship have the kindly have the Act, my lord. Section 14, my lord.
No, but see, Mr. Advocate General.
Yes, my lord.
No, are we required to go into all this at this stage?
No, I'm only answering the argument of my friend, my lord. He says that I have filed a suit, my lord.
These are,
and therefore,
yes, these are issues on merits which will be taken up and decided in course of hearing.
No, my lord, your lordship cannot decide the matter on merit. Why?
Yes.
Because it is under 227, my lord. Because I will place it is under 227.
So on the merits of the revision it can be at. But I will just interject just one.
I will place the recent judgment of the Honorable Supreme Court. This is the
I will just
issue. In merit means what he says, my lord. This is first argument. Only briefly I am answering briefly I am touching the point, because today he is trying to say please stay the order of the trial revisional the appellate authority, which under the law has attained finality. I am only arguing on the issue of stay, why it is not maintainable, my lord. First, that it is my part is to show, and limited endeavor is at this point of time is to show that, my lord, under the law this is not maintainable. This you cannot take this plea that I filed a civil suit. Therefore, Public Premises Eviction Act cannot be gone into. The order has attained finality. There is a bar under the law. That is my first argument, countering the second argument, my lord. The most important argument is that he has argued I am in possession. My lord, he has not shown even single sheet of paper. It is a government land, admittedly. In government land, my lord, he is saying I have got patta from local authority. I have got declaration from myself, my lord. If the government land, my lord, in two forums, the Deputy Commissioner and Board of Revenue held that you have no right to occupy and encroach government land, my lord, and now he gives the declaration in 227 and comes and says that no, I have patta from the local authority. Whether your lordship would intervene, because if that is so, my lord, every government land will be encroached by encroacher by getting patta, because they have to show that it is, and not a single document has shown by which he can show that his predecessor in interest inherited the property. He has the any sale deed, any document in favor of that government transferred this land to him. Find some page 79, if your lordship will kindly see why I am saying it is a government land, my lord. Page 79. Page 97, my lord. Page 97.
97.
Yes, my lord. Middle of the page, my lord. 3, your lordship will kindly see page 3.
Page of para.
Yeah, 3, my lord, middle of the page of 97. How and when land allotted in SMB Shillong, and when what is the area allotted? Revenue and Disaster Management Department, Government of Meghalaya, Shillong had allotted land at measuring 113.3 square meter of plot located in Kent Street, Shillong, by data dated so and so. No records were produced by the so and so. Then, my lord, it is evident that additional land was also recorded, was the additional land is municipal board. Question which arises, my lord. So it is a government land, my lord. It is admittedly government land, my lord. And once it is a government land, my lord, my case is, my friend should show that I have got the ownership of the land from the government, and he is a rank encroacher, my lord. And last but not the least, my lord, today I have been instructed to say that we have taken possession of the land, my lord.
No, not yet.
We have taken possession of the land. I have been instructed to say that possession has been taken over, my lord. If your lordship is inclined to issue notice and entertain the revision, my lord, we will file detailed reply placing all the materials, and we will place it, my lord. Lastly, my lord, what he says that it is the order may have been issued by secretary, my lord, but order is by the competent authority under the act, my lord. The Board of Revenue and it is separate rules, my lord. Under the Public Premises Eviction Act, there is a separate rule. And under the Public Premises Act, my lord, the authority has passed the order. So having regard to all conspectors of facts, my lord, my submission is, my lord, we can file detailed reply, but recent judgment, there is a recent judgment of the Honorable Supreme Court, my lord. If your lordship will permit, I can briefly express that judgment of Justice Dipankar Datta, my lord, in Municipal Corporation of Greater Mumbai versus Vivek Gawade, 2024, SSC Online, SC 722, my lord. Only one paragraph, my lord. The scope of paragraph 16, my lord. As paragraph 16 at at page 8, my lord. At of the page, my lord, kindly see the Honorable Supreme Court has quoted the Constitution Bench judgment at the paragraph 16, just above the quoted part, my lord. Constitution Bench decision of this court in Rajendra Diwan Pradeep Kumar Ranibala, the power of the superintendents conferred by Article 227 is, however, supervisory and not appellate. It is settled law that this power of judicial superintendent must be exercised sparingly to keep subordinate courts and tribunals within the limits of their authority. When a tribunal has acted within the jurisdiction, High Court should not interfere in exercise of extraordinary jurisdiction unless there is a grave miscarriage of justice or flagrant violation of law. Jurisdiction under 2227 cannot be exercised in cloak of appeal in disguise. What my friend is saying, my lord, the exercise of extraordinary power under 226 court restrict interference in cases of patent error of law and go to the root of decision. Now, my lord, the facts, if I apply the facts before your lordship will kindly appreciate the facts, my lord. Facts are that he is a rank encroacher. It is a government land. He has been filing multiple litigations last 10 years. By those litigations, he has lost on those litigations. Orders have been passed and possession has been taken, my lord. We will satisfy whatever lordship's queries are. But as on today, we are in possession, my lord, and we have taken possession. Now, to that extent, the matter can be gone into, and if your lordship finds that the order is wholly without jurisdiction in parameters of 227, lordship can direct parties, can direct the state to restore the possession. We can restore the possession. Lordship's power is unlimited. We are not, and therefore, as on today, my interrupted submission, my lord, it is gross abuse. Public land is under encroachment, and if we they are rank encroachers.
Well, I will give a reply, my lord. Lordship, I'll take lordship to page. Kindly come to page 40, my lord. Page 39, 40.
See, Mr. Gautam,
My lord.
like I said earlier, this petition will be heard out.
At least grant me some stay, my lord.
No, this petition will be heard out. As the Advocate General said, they will file a response, or they will make the response. They may challenge the issue of maintainability, so on and so forth. That is left open to the parties. What is concern? What is the concern of the court at this point in time is your prayer for grant of stay. On your submission or your assertion,
my lords,
that the eviction process has commenced.
Commenced, not completed.
But not completed.
My lords.
No, there is
now.
No, my lords, just commenced.
Now,
well, the state cannot.
now at this.
I've been instructed.
Yes. Now, let me. And now at this point of time, they say that they have been instructed that the possession is complete.
Yes.
Or the eviction process is complete.
Yes, sir.
So, see, there's nothing on record. Even if
from their end also.
So, if it is so, if the eviction is completed, there's no scope for passing over.
No, my lord, lordship, I will
so,
exactly what learned AG has argued. Kindly just see the order once, my lord. Is it a speaking order? What kind of an order is that?
That is today, my lord is not finally deciding the matter.
Exactly, my lord. At least lordship
my lord, eviction has been carried out, my lord. That has been instructed to me, my lord, to submit before his order.
Look at the conduct, my lord. I file a CRP in the morning, they go and evict. Look at the urgency in their case. Why do they want to do this? Because I have been in possession of the property from 1975. This is absolutely wrong. The state should be a model litigant.
My lord, may kindly appreciate. My friend has also approached the civil court, and if there was a merit of my learned friend's case, my lord, definitely the civil court, my lord, would have given an injunction in his favor.
There is, my lord, some interim order has been passed waiving the notice also, which is supposed to be given to the state. The court has found urgency, but the court went on maternity leave. Therefore, my lord, the matter could not be taken up. There was a change of board of counsel also. Kindly appreciate today, my lord. Just hear my submission for 5 minutes. I will impress upon this court that I have a prima facie case for interim stay.
See, Mr. Gautam, I said all those issues will be taken up.
But my lord, by that time, my lord, look at the conduct of the state. They are trying to throw me out. My lord, the Supreme Court has also been very clear about this kind of.
Now they say that on the basis of the impugned order.
My lords.
the possession has been taken up by.
They have not taken possession. They cannot take possession in a short
My
period of
submission
time.
may be recorded, my lord.
It may be recorded.
My submission may be recorded. I've been instructed
I
to
am
submit,
before-
my lord. Possession has been taken.
I am before a high court, my lord. Like kindly see, my lord.
Exactly, you see.
Lordship will see just page 40 once.
Whatever the case may be, Mr. Goyal, yes, there are processes or there is due process where even if you have been dispossessed and in due course it is found that you are.
Then let status quo be maintained as of today, my lord. They are saying they have taken possession. Let them not demolish the entire structure. That can also be done. Because my lord, if Lordship will hear me for 5 minutes,
Status quo may be.
whatever a learned AG has argued, my lord, that is what I am saying. He is saying appeal is maintainable. You have not even decided my appeal. You said the appeal is not maintainable.
Stay of eviction process, this court is not fully convinced since it has been submitted at the bar.
But my lord, they will, my lord, by the time, my lord, this order goes, my lord, they will throw me out from there, my lord. That is their endeavor. It's very, very
We
clear.
have already taken possession now.
Well,
Milord,
how
we
can
have
they
already,
possess-
now this is a statement which
When I have,
my friend.
Lordship, may I remind my lord, my lord,
That is why.
there is one case before the division bench before this honorable court, my lord.
Mr. Gautam.
The statements are being,
Earlier in
the
the
order
day-
has been passed. Milord.
Earlier in the day, I had cautioned you, saying that in the course of these proceedings, you may have already been evicted.
Prima facie case has not been.
The
shown.
CRP was
Prima
filed
facie-
yesterday.
Balance of
It
convenience
was
is also
filed
not
yesterday.
there.
They could have at least waited for the court. My lord, look at the conduct of the state, my lord. This is absolutely wrong.
Not
Very, very
balance
wrong.
of convenience, prima facie case.
It is in
and
my
we have
favor. I was
acted
in
as per
possession
law,
for
Milord.
40, 50 years. Well, let status quo be maintained then, my lord, that further demolition not be carried out.
My lord.
Encroachment, rank encroachment on the side.
Well, that civil court will
Can this
decide.
honorable court will allow, my lord, encroachment into the government land? My lord, I am submitting in the bar, my lord.
Everything.
What is his claim?
Everything.
Don't show a single document. that
Everything
is
has to be with.
My
due-
lord, what documents
everything
he has proved?
Everything has to be with due process.
Yes, my lord.
You cannot
that,
throw
that
somebody
we
out, my
appreciate.
lord.
There is no
that is
dispute
not
about
the
that.
May I
Due
please-
process will apply to the
And that is-
encroacher also, Milord.
and that is the
Encroachers cannot encroach on the land.
That is the concern.
Because you have to declare I am an
Encroachers cannot
encroacher.
take it to government land.
My lord, may I place some
And
judgments
encroach-
also, my lord?
As on today, my lord, he has been declared as an encroacher, my lord.
Who is
The
declared?
deputy commissioner,
Only court cannot declare. Only a civil court
deputy
can
commissioner
declare.
has already decided.
That
my
is
lord. And my
summary
lord,
proceedings, my lord. That is summary
my
proceedings.
lord may
you cannot
kindly,
declare.
my lord may kindly appreciate, my lord. One fact, my lord may kindly come to the deputy commissioner's order, my lord.
My lord, I submit, my lord, a stay is warranted, my lord. Lordship will appreciate, my lordship will hear the entire case on merit, my lord. A person
176, my
cannot be
lord.
thrown out like this. The state should be a model litigant. They
My lord,
cannot
may
use
kindly
their
come to-
force
My
and
lord,
throw somebody who's been in possession
And
for so
encroachers
long.
should be rewarded.
This is
Encroacher,
My lord, may
state
kindly
should be
come to
model
page
on
one
my
seven
street,
seven.
my
This is a
public
long
land,
drawn,
government land, encroachers
dispute.
will be there.
From
and they feel that
1975,
I
my
should
lord.
be model
1975. Kindly see, my lord. I will point out,
my
show
lord
the
may kindly come
documents.
to page 177, my lord. Para 7 of 177, my lord. If I am permitted to read, my lord.
Yes.
That upon perusal show cause reply dated 9 February 2024 and despite being given the opportunity, Srimati so-and-so, that is a petitioner before my
I was
lord,
given 5 days of
has failed to produce evidence on the date fixed for the same, that is on so-and-so, proving that the plot number so-and-so is not a government land. Furthermore, so-and-so has failed to produce any evidence demonstrating how the ancestor of the property devolved upon her mother so-and-so, my lord.
Then, my lord, kindly read the previous paragraph also. When was I given the opportunity? White later dated 31st January 2025, this officer directed so-and-so to appear on 6, giving me just 6 days to produce evidence. Only 6 days to produce evidence. And the order is passed on the same day. Look at the conduct of the state.
At least some sort of documents, my lord.
I had submitted all my documents along with my show cause. It is there. It is a part of record. It is a part of record. Lordship will just once, my lord, just once see page.
And at least
Page 40.
let him show to the lordship also any document of title in law.
Yes.
My lord, kindly come to page 39, my lord. I will prove
In the
my
entire petition,
possession.
Not a single document is there.
Kindly see, my lord, page 39. From page 39 till my lord will see page 39. Type copy is at page 40. This is, my lord. This is by the Rangmashalong confirming my possession from 1975. Kindly come to page 40, my lord. This is to confirm so-and-so has been residing on and maintaining the land near so-and-so in river so-and-so since 1975 and at present as verified by the inspection conducted by the members of the Darvashalong Lavan dated so-and-so, so-and-so. Thereafter, my lord, we'll see the next next annexure, my lord, page 41, my lord. Kindly see, my lord. How can the state do something like this, my lord?
It's government land.
How can you say it's government land? Then every land will be got tomorrow. Everyone will say government land.
Mr. AG, you may say it's government land. Yes, nobody is disputing your stand. But the thing is that everything has to be. I would reiterate.
Process of law has to be followed.
I beg to differ, my lord. I beg to differ for one reason.
Look at your
process in the name of process, my lord. Please do not take the rank in future. It is rank in future. Process is what, my lord? Process is public premises
page
eviction
57.
act. Process is public premises eviction act. If we have followed to the hilt up to the Supreme Court, my lord, and I have succeeded up to the Supreme Court, my lord. Now he's saying first round, my lord, in 2013 on technical ground he got this order set aside, my lord. Kindly see the earlier order of eviction, my lord. Now, your lordship, this is only
before that, my lord. Kindly see page 57, my lord. Kindly see page 57.
Are adopting in dilatory tactics. They are delaying the entire process.
Kindly see page 57 once, my lord.
I leave it on that, my lord.
Lordship, kindly see page 57 only once. Page 57. Page 57. The municipality board allots me a holding number. Kindly see page 57, my lord.
We will not go into that.
My lord, but this warrants a stay, my lord. Kindly appreciate. Lordship has seen the documents. Kindly see page 57, my lord. They themselves give me a holding number. Now they say that this property belongs to them. I was given building permission by Muda, my lord. From 1957, my lord, the village has said that, my lord, I have been in possession of the property from 1975. If they have a claim, what is their claim? How can I be dispossessed like
page
this?
Page 65, Shillong Municipal Board eviction notice, page 65, my lord. Page 65.
Yes, well, I've heard the parties say.
Well, kindly, my lord, I will pray before Lordship, my lord, at least give me some protection, my lord. Otherwise, once I am thrown out, Lordship has seen the conduct of the state. The state has not been.
It is under the position of the government, my lord. The land.
It is not in the under possession. It is still in my possession.
No, my lord. He has been thrown out, my lord. And moreover, my lord, whether the petitioner stay there or not, my lord.
How does it matter?
And why?
What kind of submission is this?
My lord, my learned friend, allow me to submit.
He is not even staying.
He is not. She is not even staying, my lord.
Not staying there.
How then the position is
my
under
lord,
him, my lord?
I have property over there, my lord. It's not required for me to be physically present in a property. Possession is something else, my lord. So that's a very I don't
my
know.
Lord, what appreciate, my lord.
Look at the hurry in which they want to throw me out, my lord.
He is earning from the government land, my lord. Government land.
Let me pass the order.
My lord,
this matter will not be finally disposed of.
Yes,
right now.
Yes,
I'm just praying for some protection.
We are only at the stage of admission.
I have a serious objection to that protection, my lord.
But I will observe on the orders that has been passed. Heard Mr. K.C. Gautam, Direct, K.C.H. Gautam, Direct Counsel for the revision petitioner, who has approached this, who has submitted that the petitioner, by way of this instant revision petition, preferred under Article 227 of the Constitution of India, has assailed the judgment and order dated 5/2/2026 passed by the Meghalaya Board of Revenue, Shillong, in Revenue Appeal Number capital MBR/RA/4/2025. Whereby the appeal filed by the petitioner under Section 8 of the Meghalaya Public Premises under bracket eviction of unauthorized occupants close bracket Act 1980 was dismissed. It is next the assertion of the learned counsel that the petitioner is in possession of the said land in question, and her title to the same has been established by way of documentary proof. However, apart from the proceedings before the Board of Revenue and the Deputy Commissioner, the petitioner has also instituted a title suit before the competent court of jurisdiction in this regard.
It's not competent court, my lord, under the law, my lord. That is my objection in section 14, my lord.
You are referring to? Yes.
Section 14, my lord, suit before competent court, my lord. That is the issue because
yes,
that the court will decide.
That the court will
decide.
My lord, that my case is that it is barred by law and barred by the order of the court also.
You can raise that point. You can raise at the proper forum. Yes.
Yes, because this forum is also may not be, he is relying on suit. So that is what I am saying, that suit is not maintainable.
This is just a statement of fact. It's not
It's submission, Milord, not it's submission, Milord.
Submission. So submission can be accepted, can be discarded, can be accepted, can be discarded.
Yes, Milord, submissions, I can't say that submissions can't be made. Submission can be made, but you also would certainly appreciate that the submission is on the face of it, on the teeth of Supreme Court judgment and section 14, Milord, and abuse also.
Anybody can claim. You can claim the moon, and I will say that you have claimed the moon. So, so what does it matter?
That seems right.
Before the civil court. Next, the grievance of the petitioner in this petition, as has been pointed out, is with regard to the order dated 5/2/2026. And a related order. You are also you have not made any mention to this order at page 176, order dated 6.
No, but it's fine. In my prayer it's there,
and also to the
my prayer is to stay the
and also to the related order dated
page 30,
6/2/2025, by which the petitioner has been directed to vacate the suit property, has directed to vacate the property within 7 days from the date of receipt of the order. It is the assertion of the petitioner that the said order dated 6/2/2025 was received by her only on today is 12. So yesterday you have received.
My lord, the order of the Board of Revenue I received day before yesterday.
It is 6/2.
No, my lord, 6/2 was put under challenge before the. So once that Revenue Board has dismissed my appeal, that this comes into force. That is why I am seeking stay of this 6/2/2025.
Exactly. When did you receive this order?
This was received long time back, my lord. We also filed show cause.
And there was no stay, my lord. There was no stay also. There was no stay.
When?
So, my lord, see what has happened, my lord.
No,
after
when did you receive it?
My lord, this was received.
Then only,
I think it was received on the same day, perhaps, my lord, and thereafter I preferred the appeal. And my lord, in fact, my lord, after the Board of Revenue dismissed my appeal also, my lord, they should have given me at least 15 days time to vacate. That was also not given.
Exactly.
No, there is no requirement, my lord. There is no requirement. Notice will go from Deputy Commissioner's order only. And
Everything
7
is
days was
illegal.
from, and there was no stay
Everything is
also.
illegal here, my lord. It's very, very apparent.
Everything except encroachment.
So the point
that will be decided in the course of.
The fact remains.
Authority has decided. Deputy Commissioner has decided under the Meghalaya Public.
Whatever the case may be, see, the fact remains that you have issued this notice and stipulated 15 days. For
15 days from 6/2, my lord, from that day.
But you have taken recourse within to vacate or to evict the petitioner within.
After the Board of Revenue's order, within 2 days.
If I do it in 15, after 15 days, I can take possession on any date.
You can do that, but have we crossed that 15 days?
After the date of the
Yes,
order,
my lord,
no
and
days
this
no
is
date
the
has
order
been
passed on
crossed.
6/2.
Yes,
Today we are on,
so we can take it.
today we are on 12.
No, my lord, see, so 15, his grievance is not that I need to have the position. I have taken the position, my lord.
Oh,
And
6
that,
to
and that he has
2025.
That is the initial
Sorry.
order.
I thought it's
Apart
26.
from that,
My lord, that is
and even that also, the
And
fifth
this is
order also
more
was
than
given to be
1 year,
David
my lord.
wasted.
This is more than 1 year.
Yes.
Oh, sorry, I'm mistaken, my lord. I'm mistaken. It's a more than 1 year.
More than 1
I
year.
was
That's
also
what I also thought 26.
Against that order, appeal was
Yes,
filed.
my lord.
and there was no
I'm
stay, my
sorry, my
lord.
lord.
There was stay. There was stay.
No, no.
by the
In the
Board of
appeal, there was stay, my lord. And the moment the appeal is dismissed, the stay goes, my lord.
He has to show, my lord, some
Yes,
semblance of his title on government land,
I have 10
which
documents.
he has
Holding
miserably
certificate
failed,
given
my
by the
lord,
Board of
at
Principal.
every stage. That is why he challenging
Permission
the
given by
appeal
them.
admission in the Supreme Court. In this court, my lord, every time he has filed frivolous, the appellant has filed, petitioner has filed frivolous case, my lord.
Have they shown one document to show that this is government land so far, my lord? Is there anything on record? I have 10 documents right from 1975.
It is revenue record was produced. It was seen by deputy commissioner. The khasra and khata number, everything is mentioned.
Now the trespasser will come and say, my lord, show your bona fide, my lord, to the honor.
Pulivian was stamping miss now to them. Is that she's in? Yeah, pom auto. Which, according to the Learner Council, is an order passed without application of mine and without consideration of the law in force. As such, we set an impugn order. As such, it is prayed that a set impugn order may be set aside and quashed. The second limit of the Learner Council has further submitted that in the meantime, without affording any opportunity to the petitioner to take necessary legal recourse, the respondent authorities have proceeded with the eviction process and admittedly, as on today, the said process is ongoing, though not completed. At this point of time, the Council has submitted that this petition may be admitted and the process of eviction, if any, may be kept on hold. Mr. Kumar, you are appearing for all the respondents.
But that, not my friend will.
I'm appearing for the Shillong Municipal, my lord.
1 and 2, my lord.
1 and 2 is the
State. I'm for respondent number 3, my lord.
So state of and deputy commissioner, my lord, 1 and 2, my lord.
Board of Revenue is represented by state.
No, Board of
My
Revenue.
lord, there are 3 respondents here, my lord. State of Meghalaya, deputy commissioner, Shillong Municipal Board, my lord.
Board of Revenue is not a party, made a party.
It's not a party, but
It's a quasi-judicial authority, my lord.
State is defending the order
no,
of the
it's a
deceased.
quasi-judicial. That I understand, but it has to be
Yes, my lord.
it has to be represented by somebody. I mean, somebody has to defend the impure order.
No, my lord, that's not required in law. They are judge. They have passed the order in the
No, that they are not.
exercise.
I know. Yeah, they are
So,
not required.
therefore, in fact, recently, your
So-
lordship
so
has
you-
deleted MSCRC, which MSCRC passed the
So
order.
you
Your
are,
lordship
so
has
you are,
deleted.
anyway, so you are defending the impure order.
Yes,
I am defending impugn order on behalf of the government.
Exactly,
my lord.
on behalf of the government. And that's what I want to be clear.
Yes, my lord.
Mr. A. Kumar, Leonard E.G., along with Ms. has accepted notice on behalf of the respondent number 1 and 2. As such, no formal notice is required to be issued on such respondents. Next, similarly, Mr. S.D. Leonard, are you counsel or standing counsel? Or
I'm
what
a standing counsel, my lord.
Leonard, standing counsel for the respondent 3 Shillong Municipal Board is also present and has accepted notice on behalf of such respondent. The Leonard E.G., in response to the submission made, has submitted that the petitioner has no case whatsoever to pursue before this court or before any forum for that matter, since she has not been able to establish her right and title, and that the land in question is without doubt a government land, and as such the petitioner has become an encroacher in that sense. The impure order passed in this regard is therefore justified, and furthermore the eviction process carried out cannot be questioned. It is also the submission of the Leonard E.G. at the bar that as on date, the eviction process is completed and the petitioner has been removed from the said premises. As such, the question of stay of the eviction will not arise at this point of time. This
And suit is also not maintainable, my lord. Suit is also
that is the difference
against section 14.
that I will not say at this point.
This is my submission, my lord. Your lordship
Yes.
has recorded the submission of my submission, my lord. That lordship will
fine.
decide later on.
They will take this and go to the civil court and influence the civil court saying the suit is not valid. That may not be recorded. That is something
Because
they will raise it
your
there.
submission of my friend was, my lord,
Yes,
I
yes,
just one line. The submission of my friend was that I
Leonard-
filed civil suit and therefore
Leonard
there
E.G.
is not.
The Leonard E.G. has also responded to the submission made by the Leonard Council for the petitioner to say that the suit filed by the petitioner is not maintainable and the same will be challenged at the proper forum, before the proper forum. Next, Mr. S.D. Leonard, standing counsel for the respondent number 3, has also submitted at the bar that he is instructed to inform the court that the eviction process is complete and that the petitioner has been dispossessed in accordance with law. This court, on consideration of the submission made, at this point of time would not go into the merits of this application, but would deem it proper that the same be admitted. As has been prayed for, the respondents are allowed to file the response if in due course. As to the next issue of stay of the said eviction process, in view of the conflicting submission made before this court at the bar, at this point of time, it would not be proper for this court to issue a blanket stay of the said eviction process. Be that as it may, as has been prayed for by the legal counsel for the petitioner, status quo will remain.
And no further demolition may be carried out, my lord, at least.
So, status quo means if it is done, then none.
Milord,
Can be done.
only on the Milord, with respect, Milord, only on the prayer, Milord, on government land, please do not grant, because every rank encroacher will come and will ask for status quo, Milord. When I take a position,
only
you will have, you have to protect the government land, Milord. He is encroacher, Milord. He has not protected document. Please don't give him the relief he is asking for. That is the he is praying and lordship is granted. My statement is, Milord, I have taken position.
You can file.
I am in position of government land. Now, Milord, he says that
Mr. Kumar,
simply disputes it.
as only,
Not
you can file.
It will not.
You can come with an application for modification.
You know, Milord, I was praying, Milord, before the lordship will grant.
That is all.
That is always that because a status quo. I can see a status quo is fine.
See,
but
Mr.
in my position.
See, Mr. Kumar, Mr. Kumar,
you have not taken possession.
Listen to me. You have stated at the bar that the eviction process is complete.
Yes, my lord.
Which means that
I've taken position.
Okay, so now you are staying there in that land.
Yes, my lord.
I disagree, my lord.
So that whatever you may disagree, but that's the assertion.
That's the assertion.
So yes, there. Status quo means you remain there.
Yes, my lord.
But no further demolition, at least.
But the only issue is that if your lordship will see, my friend can show photographs, completely hutments have been created. So if your lordship will say that don't remove hutments, how will I use the government land for my own?
Till this CRP said, at least it can be status quo can be.
This is the photograph that they have been removed, my lord.
No, my lord.
Now, by taking advantage of this order, my lord, they will go status quo, my lord. This is the photographs, my lord. They have been removed, my lord.
Lordship, I have demonstrated my lord, from 1975 I've been in the property. Well, I don't know what the state is trying to do, my lord.
We'll not go into this. We'll not go into this 1975.
State is, I don't know what is trying to do, my lord. They're trying to, my lord, throw me out, dispossess me without following the due process. Yeah, this is not, this kind of submission should not be made, only thrown. I was talking about a human being, my lord. We're not cattle. We're not cattle that you just throw somebody out.
I will keep quiet. I can't.
What kind of submission is thrown out? A person, a woman is in possession of the property from a mother. So position can be physical, cannot be physical also. That is something, is a point of law. How can they refer to throw out? Well, we are human beings. Lordship, 1975 onwards we have been in the property without the order, my lord. What kind of order is that?
Whatever the
No, no,
case,
you
At least,
sit
my lord,
here
one
in the
small
government.
prayer.
whatever the
High
case,
Court
Till the next
premises
date
say
only.
that I am in chief
Till the next
premises,
date
I
only, my
can't
lord.
be
No
thrown
further
out.
demolition may be carried out. That's all I'm asking, my lord.
You
If
know,
they have
you
a
not,
case, they'll win.
this
Why are they
is a
so anxious
government
to throw
land.
me
What
out?
is the hutment? Hutment is there. All these are illegal tenants. He has given it to me, Lord. That is what my officers
And the
also
worrying
told
part
me.
is this,
And
my
Mr.
lord.
Day can confirm, my Lord.
My lord, if I can make a submission before this honorable court, my lord. That place has been used, my lord, by the drug addict, my lord.
What kind of submission
Please,
is this?
please let me submit. You cannot make everything fun. Everything cannot be right. He cannot be right in everything, my lord. He has to allow me, my lord.
What bearing
If
does
we don't remove those hurdles and all, my lord, then this place will be a drug addict shade, my lord.
Absolutely.
My lord,
wrong submission.
can you take note of my submission, my lord? My lord, my lord,
that is not a valid submission.
no, my lord, can you appreciate, my lord? Once they have been removed, my lord, they have taken.
You give your justification at the proper forum.
We'll give, my lord, but at least this submission may be recorded, my lord. That the
No.
we have taken the position.
You have that has already been stated. That
My lord,
eviction process is already completed. That has been stated.
That may be recorded, my lord. That is what.
That has been recorded.
It has been
My
recorded.
my lord.
It has already been
No
recorded.
further demolition, at least, my
My
lord,
lord.
will take advantage of this. My lord, lordship has already seen their action. Their anxiety in trying to dispose me today itself. If they have such a good case, they can wait for 2
Taking
weeks.
submission is not an
You
anxiety,
also have
Mr.
you also have your recourse.
Kishore.
You also have your recourse.
Yes, ma'am.
I think this matter is not before this bench.
It will go before some other bench.
Yes, sir. Omno tuka status quo order. List this matter before the regular bench. After 2 weeks.
Yes, my lord, after 2 weeks. We'll try to.
At least this may be communicated by the learned AG. I'm sure he'll be, my lord, at least kind enough, because otherwise the entire thing will be over.
The the government advocate will communicate.
Thank you so much.
AG is
without your direction, they will not do. Without
no,
your
this is a
direction,
government advocate. I am the senior advocate.
absolutely.
Without
Without your permission, they'll not do. That is the prayer I was making.
No, it has to be. It is there. You can circulate YouTube video also. There is no problem now.
much obliged. Their job is done. Their job is done.
When you see, the only thing is now you have your legal recourse to get back possession. That's all.
Absolutely, I have that.
That's all.
Yes, that is correct. Lordship is right.
Much obliged.
Highly obliged.
Much obliged.
Much obliged.